As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. We are now turning our attention to the Murdaugh trial. This is something that this channel has talked about a couple times before. Alex Murdaugh, disgraced attorney. His family has been a powerhouse attorney's family in Low Country, South Carolina. This is the Charleston area, broadly speaking, in the southeast corner of the state, where his father and his grandfather and his great-grandfather have all been the chief prosecutor of the region for the last 100 years. And he himself, of course, is a lawyer, now disbarred, who has been accused of a lot of things. Many of them, most of them financial. He is, last I checked, been accused of 103 different counts. We're not here for all that. At the moment, we're here for the murder of his wife and child, but he has been accused in other indictments that are still pending for various financial frauds relating to his work as an attorney, principally stealing from the clients to the tune of something like $9 million last I checked. And he is been accused of bank fraud, wire fraud, honest services fraud, embezzlements, and just like basically everything else. But that's not why we're here. We're here for the murder of his wife and son. So the story, I suppose, begins with his son, who committed a DUI on boat that led to a death. His son was driving a boat. He was drunk, and while doing so, he killed a woman. And he was being charged with that crime. And that happened about 2 or 3 years ago at this point. And that seems to be where things really sort of unraveled. Like, the story probably precedes that in a lot of ways in terms of like the frauds and things like that. But that seems to be where the story really unravels, is with the murder, was with his son committing this murder. And it seems that from that process, that whatever sort of facade he had was beginning to become unwound and was going to be exposed. And he would go on to hire someone to murder him for the insurance fraud, which is also one of the charges. So he tried very unsuccessfully to end his own life via a hitman, so that they would collect on like something like $2 million of life insurance money, so that he would be able to exit from this realm, leaving his family with something. But he lived through the experience, so not very good in terms of that. And he has apparently killed his wife and son on his South Carolina home. So we're going to be covering this every day as sort of our working plan. I appreciate the 414 of you who are here. I really do appreciate that. Please make sure to like, comment, subscribe. Just do the like. How about that? Just hit like. Just hit the like button. It's all, you only have to do one thing. Just hit the like button. That helps with the engagement, and that will be great. So that is sort of a brief rundown of our story. And John says it was the civil lawsuits that wanted to see the books. That's quite probably true. That's quite probably true. That is likely the result. Also, he might have murdered his housekeeper. We're not sure about that, but there is strong suspicion. So in perhaps the most chutzpah move of chutzpah moves ever, it is possible that he murdered his housekeeper, and then possible that he worked his way into becoming the attorney for the estate of the housekeeper, and then possible that he won a judgment, which he then stole. That has got to be the most chutzpah thing of chutzpah things ever, right? I kill the woman, then I represent her estate, and then I steal the money that we retrieve. That is just a whole thing. HBO Max has a 3-part documentary series going to the whole backstory of the family called Low Country. Cool. You might want to check that out. I'm going into this thing comparatively blind. I've kept my toe in it to be sure. I know sort of the basic fact pattern. I know the basic accusations that are accused, but I don't really know what the evidentiary picture looks like in terms of the evidence. I don't know what the state has or not. I've watched some of the preliminaries. I will say that in the preliminaries that I watched, I was very impressed with both set of attorneys. So I hope that will continue to be true in this John Grisham novel come to life. I found both sets of attorneys to be very competent and very diligent and very good, and the judge to also be good. So this might be, hopefully, a really good example of good lawyering and good judging from everybody. That'd be nice. When was the last time that happened? When we didn't have strong criticisms for someone in the courtroom? We'll see. But that's what's happening. And so I don't really know what the evidentiary picture looks like in terms of the evidence. They have some 911 calls, obviously. They have the 911 call where he reported being shot in the head by the guy he hired to do it for the insurance fraud. They have 911 calls. And I suppose a lot depends on in terms of how deep we're going to get into the financial stuff and what the judge does let in and does not let in. A lot of that's been decided in preliminaries, obviously. But there's still, what actually is going to develop from the witnesses, what's actually going to develop. So it looks like a very circumstantial case. We have the wife and son killed on their home. Their home, by the way, is in the middle of nowhere. He has a huge estate. So it's, not a lot of people would have access to it, presumably. So it does keep the suspect pool somewhat smaller, as opposed to just being a home in downtown Charleston or something where, it could be someone off the street. This is, a multi-acre plantation that he has that, is not off the path. Also, he might have killed a different person. There's suspicion that he killed yet a different person, a guy who was found on a road near his home at a different time. So he's been charged with 2 murders and suspected of 2 other murders. So we'll see what the evidentiary picture looks like. I don't really have a strong opinion on this case. I mean, I feel like I could be a juror in this case if I were in the right jurisdiction, although they never have me as a juror because I'm an attorney, and most of the time that's a problem. Although where I used to live, Northern Virginia, that wouldn't have been as much a problem because everyone's an attorney in Northern Virginia. But I feel like I could be an attorney because. Thank you for the super chat. Trying to wonder why I'm not hearing the thing being read. Can you guys could you guys hear that being read, or did it just pop up on screen? I couldn't hear it. Maybe it's because I have my this audio muted. Maybe it muted everything. I don't know. No? Okay. All right, cool. Just checking on these things. I like to know what's happening. Let me go ahead and open up that super chat so I can go ahead and read that myself. From Andrew J. said technically he got the housekeeper's kid to hire his friend as an attorney of the estate to sue him. Then he got the friend to steal the money. Okay. I stand corrected. I didn't realize it was a friend that was representing the state. I thought it was him proper. Thank you for the correction, Andrew J. Yeah, but anyways, I feel like I could be a juror in this case because while I've heard of Alex Murdaugh, certainly, and while I have some basic familiarity with sort of the accusations, I don't really know the evidentiary picture. And I don't really have any sort of belief at this time in his guilt. I mean, there's certainly some circumstantial evidence that suggests him as a suspect. The fact of where the location occurred, and there's certainly some motive. Motive helps a lot, right? He was ashamed. He did it for the money. He killed them in a sort of an honor killing kind of idea. right? Maybe he killed his son out of sort of like an honor killing.
This guy sounds like an entire series of Book of Crime drama.
There's the announcement. I don't know why the first one didn't read. I really don't. But thank you very much. Yeah, this is definitely a Book of Crime drama. I agree with that completely. I agree with that assessment completely. There are a lot of Brits here. Excellent. Yeah. So this is some John Grisham novel come to life. That is what is going on in this story. That's basically what's happening. This is a John Grisham story. Spiritual says, is that the law or unspoken rule that lawyers are never allowed to be on a jury? It's an unspoken rule. It's not the law. Where I was in Virginia, if you're an active lawyer, you can choose to exempt yourself, but you don't have to. But to the best of my knowledge, nowhere is it an automatic disqualification. Like it's like you can't do it. But yeah, most of the time, the idea is that you don't want an attorney on the jury because it becomes a jury of one, right? Is that because the idea is that this person is going to wind up, driving the entire thing, and their knowledge of the law might be a problem. But there's nothing that excludes it. It's just a standard rule. It's like it's sort of a cliche. But that being said, in Northern Virginia, where I used to live outside of DC, everyone's a lawyer. So I've definitely heard of situations where lawyers, and sometimes multiple lawyers, wind up on juries. So it's just one of those things. It's that this person has too much knowledge, too much information, and they'll wind up running the entire jury themselves. So that's what's going on. You love the thumbnail? Thank you very much. I created it, obviously, and I thought it turned out pretty well. And I will obviously be changing the thumbnail, or maybe not obviously, but I will be. I'll be changing the thumbnail at least every day. I'll keep keep the mug shot, and then I'll change like the left portion to represent different things that are South Carolinian in nature. By the way, for my own sort of bona fides over here as to why I am best attorney to cover this, although I am not licensed in South Carolina, I grew up in South Carolina. I grew up in Columbia. That's where I was raised. It's where I went to elementary school, middle school, high school, and college. I'm a graduate of Clemson University. Go Tigers. And so I have quite a little bit of familiarity with the Palmetto State. And my family still lives in South Carolina. Both my parents and my brother live in South Carolina. My brother lives near Charleston. My parents live near Greenville. So that's sort of my claim to particular credibility here, is that I am familiar with the state, and I've lived in Low Country, South Carolina for a brief period of time. I lived in Beaufort for a little while. So all those things. Graduated College of Charleston. Yep. Columbia area. Yeah. Yeah. It's Peter Tragos on TV. Let's listen to Peter Tragos. I don't think they will mind me copying the audio.
Peter, for the jurors, we now know that jury selection is underway in this Colleton County Courthouse. How difficult is it going to be to find an impartial jury? How difficult is it going to be to keep this train on the track, so to speak?
Murdaugh.
Focus on
I'll try to get it right.
Good morning to you.
Good morning. Thanks for having me, man. Yeah, this one, it's going to be really interesting to think and hear about what comes in during this case and what doesn't. Because when you just talk about scratching the surface, or you talk about a web of criminal activity and things going on around Alex Murdaugh himself and his entire family, it includes potentially faking suicides, insurance fraud, suing himself and then stealing the money from his housekeeper / victim of wrongful death in his house, murdering his son and wife, covering up DUI deaths potentially caused by his son. All of these allegations coming in literally just scratch the surface as to what has come to light for a guy who's also been accused of stealing money from his clients and his partners and banks. It's going to be wild to hear how the prosecution puts together this case, because they want to talk about the financial crimes. They want to explain that that was the motive for him having to take the lives of his wife and his son, because it is so hard to believe why you would ever do that. Why would a person ever do that?
I just hope with the ongoing trial, this crime drama book does not turn into a Stephen King novel, where someone gets screwed.
He had no other choice but to try to.
This is going to be John Grisham or Stephen King or a baby child of all of them, is what I'm saying. Thank you, Fair and Frozen, for your $5 super chat. It's appreciated.
KJB, if you'd like to have your, a lot of folks saying hello to Peter, myself, in the comment section, as again, this is likely going to begin a very
Peter is a good-looking guy, but he doesn't have a cool hat. So,
let me show you, by the way,
just saying.
This to you. This is the Carlton County Courthouse and on Hampton Street. And I got this mixed up earlier. Not in Hampton County, Carlton County, South Carolina, the Low Country. And this is where inside this courtroom right now, jury selection, that process has begun. And we're going to pick Peter's brain here as to what that process is going to look like and how long it might take.
Does it read the emojis? It does read the emojis.
Underway.
It could be fun and exciting for everyone.
You're looking for, in particular, what you're looking for is coverage from inside the courthouse. As I understand it, it's been told to me, and I'd like our YouTube audience in particular to help me out here. It's been told to me that the jury selection process will not be accessible inside the courtroom as far as live streaming goes. There will not be a feed that is permissible from inside the courtroom during jury selection. And we can talk a little bit more as to why that is. We'll break that down here in just a moment. But if anybody sees any courtroom feeds right now, I don't think you should be seeing it legally, because there is going to be a live stream from inside the courtroom, but it's actually when the trial itself begins with opening argument.
Yeah. So there was some ambiguity.
Especially because
there was some ambiguity as to whether or not the jury selection process would be filmed. So if it's not filmed, I don't know if I can vamp for days, because the jury selection process will be days.
Some of their answers. So if the whole public was watching all of these people just coming there to do their civic duty, answering questions about, have they ever been the victim of a violent crime? Has anybody in their family ever been the victim of a violent crime? Have they ever been convicted or accused of a crime? And they have to go through some details that are uncomfortable. And a lot of times we try to put them at ease that none of this is going to be, held against you. Nobody's going to talk about.
I've gotten conflicting information.
Nobody's going to hold any of this against you. We're just talking about your.
The video I'm showing is low. I've turned it down a lot.
The way you look at this case,
but I can turn it up some more.
When they talk about, their child or husband or uncle was brutally murdered, and that may affect how they can handle sitting on a case like this. Well, we don't want to watch that, right? The public at large shouldn't be able to watch that. They shouldn't find out these things about these jurors. A lot of times throughout jury selection, we will call these jurors by their names, Mr. Smith, Mrs. Smith, whatever it may be, and not the juror numbers like we see in a lot of these high-profile cases. So this is really digging into the personal lives of the jury, or of the potential jurors, I should say. And a lot of times that's private information. So I think it's better off that it's not live streamed.
So Carlton County is where this is all going on. As I understand it, there's a pool of more than 1,000 jurors, and of course they have to whittle that down and find the 12 best jurors. Is finding a jury? I know that jury selection is it's a section of law, and it's a section of our justice system that isn't talked about enough, in my opinion. But when it comes to finding jurors, is the number one criteria finding jurors that are as impartial as possible, Peter, or is that impossible given the magnitude and the publicity of this case?
I think, if you want my honest opinion, every juror walks in there when you hear of a murder trial, and they want to get the person that did it, right? I also think that in a lot of jurisdictions, the jury can't know necessarily what the penalty for the crime is going to be. And when you're talking about a drug offense or a lesser offense or even battery or something like that, they may not know exactly what the criminal defendant is looking at. But when it's murder, when it's double murder, they know that this is going to be a life sentence or death sentence. In this case, it's just going to be, they're just looking for life without parole. I don't know in this county if the jury knows that, but they know it's going to be serious. They know it's going to be the rest of his life in prison. They know he's never getting out again. So they know it's the highest magnitude, right? It's not like they think he's just going to get probation, so this doesn't matter. Let's just convict him and move on. So they know the gravity of this situation.
Thank you very much.
Thing you really
Colorado
want is
Mountain
somebody
Girl.
that's not going to come in there with their mind made up already. Somebody with an open mind that's going to listen to the evidence and see if the state does clear its burden of beyond a reasonable doubt before they come back with a conviction.
Let's get to some of the comments coming in. You can use hashtag HeyJB. You can use hashtag lawyer you know. And actually, it's not loading up here. I'm going to see if I can. I think I forgot to paste this code in. Hold on a second here, everybody. This is live streaming. Welcome to some of the craziness that goes on. Peter knows a little bit about it.
Thank you for the 800 of you who are currently watching. I do really appreciate everyone who's here to join me for this trial. That is incredibly validating and encouraging. I appreciate it.
After selection is made. And I'm not sure if I follow this comment. Maybe there's more to this comment that I'm not reading, that I don't really fully understand. But this trial is going to begin after jury selection occurs, right, Peter?
So I don't know the background of Skipper D, but there are some certain situations where we pick a jury and then we don't start the trial till next week, or we pick a jury and everybody starts the trial on the same Monday. We use this week to pick jurors. I don't know if that's what this jurisdiction is. It does not seem like that. It seems like because of the high profile nature of this trial, my guess is they've cleared most of the other trials out. It's supposed to go till, I think, February 10th. I think they have planned for 2 days of jury selection. I will tell you that if the criminal defense attorneys want to take more time, it is unlikely that a judge cuts them off because of the constitutional rights of the criminal defendant. In civil cases, they're much more likely to cut us off if we're taking too long. But when you're talking about the constitutional rights of a criminal defendant, if his lawyers, now, if the state is going too long, the judge may cut him off. But if the criminal defense attorneys, the constitutionally protected attorneys, want to continue longer than 2 days, sometimes the judge will allow that. They should allow that just to avoid any appellate issues. I would expect the trial is going to start as soon as they have a jury picked. Now, sometimes they'll pick a jury. If it's supposed to last 2 days,
we got Screaming Goat ready. I do.
Maybe they won't actually do opening statements until Thursday.
Lol.
Something like that, but I don't expect a long delay after the selection's made.
Peter Tragos, the lawyer you know, joining us here live on WFLA Now. Folks, give him a follow, of course, on his channel as well as we break this down. I'm going to be paying attention here in the WFLA Now Stream Center to your comments, your questions coming in. And I see that a bunch are just now starting to come in. We'll kind of.
All right, I'll turn the volume way down because I, just wanted to hear our friend Peter from Lawyer You Know. Great channel as well. Jury trial selection is underway. Okay, cool. So they're doing 2 days of jury selection, then we're going to have a trial on Wednesday, maybe. Does everyone have a stupid goat? Everyone has a stupid goat. We have the goat. We've got all the sounds. We got so many sounds.
Quite a grip over as far as legal influence in the area, and there's so many other cases and so many other names that have been connected to this case.
Was he back? Okay, I thought the interview was over.
The death of Mallory Beach and what happened with right there on the right side of your screen, Paul Murdaugh, the 22-year-old son who was in a fatal boating accident before the murders took place. Stephen Smith, a case that has been reopened, a teenager who was found dead on the roadway. Gloria Satterfield is another name that has been connected to this. There's so many cases that are interconnected that comes back to this one. How much, Peter, do you anticipate other cases and all of the connections to the Murdaughs coming up in the actual trial itself when it does in fact begin?
Thank you for the super chat.
So there are literally, there's anywhere you can start here, but just thinking about the fact that he's been accused of stealing money from clients and from the law firm trust account and from his partners. If they put on notice all of the potential former clients that may have been affected by this, that could have been literally thousands of people in this area, in and around the state, that could have been affected in a potential victim.
Good morning, Alan. Thank you for joining us from Facebook. Appreciate having you here, by the way.
Allegations. So we just start there and it kind of grows. Anyone that knows anybody that's ever hired anybody in the Murdaugh family, anybody that's ever been in this courtroom before, as we found out in a prior hearing, his grandfather's portrait hung in the back of the courtroom, which they removed for this trial. But if you've been in this courtroom before, maybe you'll notice there's a picture missing.
Yes, the public is there.
You ask the question.
It is open to the public.
What is the connection?
So it is
an
open court proceeding. It is just not being televised.
The media surrounding this case.
So yes, the public is there, and I think James from court is down there in person.
That have been done on every mainstream media news channel. Anybody has seen that, where they're obviously slanted in a way that is going to make it seem like Alex Murdaugh did this, and he very well may have. But if you've seen those documentaries, if you've seen evidence that may not be admissible, may not be coming in at trial, then you would not necessarily be in a position to be an a fair and unbiased juror for this case.
Let's go to some of the comments that are coming in. You can use hashtag HeyJB or hashtag lawyer to have your comment featured here on screen. Sally Davis, hashtag HeyJB. Our local coverage of this has been constant, but the hardest part is how many people have had negative interactions with this family. I want to bring up one thing really quickly, and this is
my mic is sounding
really,
fuzzy.
really important to me, and I hope that this resonates with our audience.
Is it really?
Very,
I hope not.
Cognizant of the fact that this story has been covered,
check 1 2
just so
check 1 2
over the last
check 1 2
so many reporters in South Carolina. I'm gonna be the first to tell you, so many reporters and so many journalists.
Do we have any idea how long this case is meant to go?
I hope to have them on this live stream. I hope to bring them on.
This case is supposed to go to February 10th, I think they've said. It's clipping.
Questions, your comments, and over the course of the trial, we
all
try
right, let me
Peter will be doing it on his channel. I'll be doing it here on the WFLA channel.
Just turn off noise reduction completely.
Possible, but I want to also be as respectful as possible, because there are some reporters and journalists who have been living and breathing this
Let's see if that helps.
Ever since really day one. I mean,
just turn off all the noise reduction. See if that helps.
With Paul Murdaugh a couple years back. So that's a really big thing here. And then, of course, just how many people
click now and then in the mic.
Murdaugh name for various
crackling
reasons,
better,
one reason or another. For 5 counties, Peter, this is a name that people have known for years, for decades.
Okay.
And the
hopefully this will work.
That they have wielded cannot be.
Thank you for letting me know. I do like to get the microphone right if I can.
Yeah, I mean, I'm sure in every area you've heard of a lawyer or a law firm that's been
slow down the chat. I can do that. Hold
or a
on.
huge advertising law firm that's been in your face on every commercial, billboard, things like that. Just try to imagine if it was that family, thousands of clients, thousands of people that know it, and then take it multi-generational. And that's the wild thing. I mean, most times when I go to pick a jury, my dad's a lawyer. I'm a second-generation lawyer here in Pinellas County in the Tampa Bay area. So my dad's been here for 40 plus years as a lawyer. There's almost every jury selection where I know at least somebody that's going to be in that potential jury pool. So just take that.
Start with slow mode at 15 seconds and go from there.
Multiple family members in multiple generations. It's not just father and son, right? So when you deal with something like that, there's going to be tons of people that may just be friends of the Murdaugh family and may think positively of them. So we're all thinking the negatives, people that have been affected, people that hate this law firm or hate this lawyer, hate this family. There's going to be a lot of people that they've actually helped. A lot of people that love them, a lot of people that still believe in him.
Thank you, Anna, for the super chat.
Would also be
it's very, very generous of you. Thank you very, very much.
So it's going to come from both sides. It's going to be very hard to pick a jury, I think.
Really appreciate all you guys who help to support the channel.
And they are ready for the media circus and the amount of people that are coming. There have been articles out about how they're setting up food trucks and doing certain things almost like there's some attraction coming to their small town.
Let's go to this. Nebraska prima donna, hashtag HeyJB. Any updates regarding the mysterious death of their housekeeper that he also allegedly...
Yeah, USA Roxy, that's the accusation. He killed his wife and adult son. That seems to be the accusation. The mic is still cutting a bit. I don't know how to fix it any more than that.
Because this is the one charge right now connected to Gloria Satterfield. That
if it's still cutting, I don't know how to solve that problem.
The confession that Alex Murdaugh was responsible for really swindling the really Satterfield's kids out.
This is the power of my voice.
I think it was $4+ million, Peter.
I can't remember the exact number. I did a video breaking this down. This was incredible to listen to the story. And just to be clear, he didn't plead to causing the mysterious death, because that's kind of what's around the question. I know that's not what you were saying. But just to be clear, since we're talking about murder now, he didn't plead guilty to that.
On the mic? Yes, I do.
Basically, in a nutshell,
is the gain too low?
She tripped and fell down some stairs at his house.
Do I need more gain?
Murdaugh's house. She ends up dying, so it's a wrongful death claim. He ends up telling her kids to hire this lawyer and sue himself. So they're suing his homeowner's insurance.
Check all the wire connections.
They settle the case with a lawyer friend of his. And they end up sending a chunk of the money, because in these kinds of cases, you can send it to basically have somebody invest the money for you so it can last longer, it can make money, and it sounds really good. And a lot of times we will use companies or financial planners to do that. Well, Alex Murdaugh himself
Reduced
set
gain
something
slightly?
up. So they sent the money to basically a sham corporation. So he was able to take the money
Yeah,
and
turn it down to
run. Basically, he
50%.
didn't
See if that
run, but he was
helps.
able to kind of keep that up until it all came crumbling down when other people looked into it. And that's what he's pled to, is basically swindling them out of sending him the proceeds of the settlement from his own insurance company because he talked them into suing Alex Murdaugh.
Yes, any charges related to anyone's death, Gloria Satterfield,
Check
victims
1,
of
2.
those are
Check 1,
just
2.
terrible stories that have unfolded.
Dooba dooba doo.
There's been no. Alex Murdaugh has not. He has pled not guilty to murdering his wife and son, and the other cases we're still learning about to this day. I mean, this is still plot lines that are still unraveling. As far let's bring things back into focus, Peter. As far as the double murder trial that we now have in front of us.
Still
I've been
crackling?
researching this over the last week plus.
God damn it.
And trying to really grasp the evidence as best as possible. And my initial take on this, I mean, we're going to learn more at trial. We're going to let, of course, the prosecution make its case. And we are, of course, going to hear, the defense try to really disprove all the evidence and all the testimony that comes forward. But as I understand it,
I want the microphone to sound perfect. I want the lighting to be perfect. I want everything to be perfect.
Oh, no, it's far from a slam dunk case. They've got issues with not having the murder weapon, 2 different weapons apparently being used. We've got some, I don't want to say destruction of evidence, but evidence not being preserved appropriately maybe, and that's going to affect the blood splatter evidence and experts. And then they've also found some memos to where the first expert said there's nothing here we can use. The second expert said there is. There's also some open motions in limine, meaning each side has asked the court to not
how's
allow
Louis
certain
Rossman in
evidence
real life?
or
Pretty much
to
the
allow
same way
certain
he is
evidence in, and the court hasn't made the final
his
decision on
channel.
that yet. So, and that's
He's
one of those is motive, the financial crimes,
He's
and all
fine.
these
He's
other
a nice
bad
guy.
acts of Alex Murdaugh that haven't been proven in court. The state wants to use them as motive, which means they're going to be able to really use the generally bad guy rule, as we say in criminal defense cases sometimes, and just pile on about what a horrible person he is, which obviously is prejudicial and makes the jury more likely to convict. So we don't even know exactly what evidence is going to be allowed in this trial, which is why it's so important to find jurors who don't know about any of it. And they're going to hear about the actual evidence for the first
Pretty
time.
Mama Bear
Now, they
Court
can have
has
seen a news
started.
article or
It
know that
seems
he's
that the
accused of this
it
or
seems there will
something
be
like that, but
no
they can't
feed
know
from the
about all
courtroom for jury
intricacies about all
selection.
the other things he's accused
So
of,
we might
or
just
they may not be
do the
unbiased
morning
walking
today
into
and
this courtroom,
then
walking
wait
into this
until
trial. And that's what's
Wednesday
most
and then
important
do
about what we
the
want to protect through this jury
and
selection
do the trial that way.
Let's go back.
I'll bring the mic
to
like real close to
exactly the circumstances.
Bring the mic real close to
surrounding
my.
this and what we know about that June
Bring the mic
2021
super
night
close.
when
Yeah.
Alex Murdaugh is again accused
Oh.
of murdering his wife Maggie and his son, his 22-year-old son, Paul. This happening, of course, at their hunting lodge, not too far away from where the family lived. And as I understand it, Maggie was living closer towards the beach, towards the coast, for a lot of the time. But really, this happened at their hunting estate. Now, as it's been laid out in front of us by the prosecution, Paul and Maggie are at this dog kennel at night when they are gunned down. And again, the 2 weapons thing, we're going to break this down a little bit. The 2 weapons thing is still something that, as far as the trial goes, I'm very much anticipating hearing more about exactly how the 2 weapons were used and also where the weapons are to this day. But Paul was found dead of 2 shotgun blasts, 1 to the chest, 1 to the head. We had Maggie, who was found deceased of multiple rifle shots from an AR-15 rifle or style rifle to the chest, and then 2 while she was laying on the ground. Investigators determined that there were 2 shots fired directly into her head, pointed downward while she was laying down on the ground, again outside the dog kennels. Now, Alex Murdaugh has claimed that he left the property that he was going to visit his mother with dementia, and that is part of his alibi. And also, too, how that alibi actually is introduced in a court of law, and how digital evidence will come into play. Peter, that's going to be really at the core of this, as well as the blood splatter evidence, because, again, I'm introducing this for the first time for our audience who might not be familiar with this story. Alex Murdaugh's clothes had allegedly had blood stains on them. And whether or not those blood stains are consistent with the splatter of a close-range shotgun blast or from a rifle blast, again, a rifle blast from standing over your victim, standing over the person that you just shot.
Did I listen to the Chauvin appeal?
Really,
I didn't listen to it, but we could do that today.
Peter,
that'd be interesting. We could listen to the Chauvin appeal. That might be fun.
And the blood splatter evidence on his clothing.
The U.S. Supreme Court might also release an opinion this morning, so I'm waiting for that.
How it's going to come in.
The U.S. Supreme Court releases an opinion. We'll cover that too.
Focus of the motions in limine for the defense attorneys at the last pretrial that was streamed that you can check out and listen to them argue. And the judge, you know, is kind of going to, I think they're going to let some of it in, but they're going to let the defense attorneys really poke holes in a lot of what that quote unquote expert has determined based on a shirt that is no longer testable, as the defense says. The alibi is going to be really important. The witnesses testifying as to where Murdaugh was, how long he was there.
But you were my runners back in 52.
Probably a lot of questions, a lot of focus by Murdaugh's lawyers.
Opinion on the attorney-client privilege, it was a great oral argument. I hope the Supreme Court's going to expand attorney-client privilege.
Focus on for the alibi.
The 9 o'clock hour is when the murders are believed to have occurred. Really, I believe that it was pinpointed to be approximately between 9 and 9:30 at night. The 911 call comes in about an hour later, an hour after that. There's also, prosecutors have say that they have evidence that includes a video.
No, I'm sorry to hear that Castrol about your mother.
Him saying really otherwise.
My hearts go out to you dealing with your mother. I hope
the timeline.
I hope everything will resolve as well as it can.
Is going to be key.
And
I've got only about another 9, maybe 10 minutes if I'm lucky with Peter Tragos, the lawyer you know there on the right side of your screen. So
we're here for you.
Comments. We'll continue to discuss the particulars of the case after Peter departs, but I want to get to as many of the questions out of the Q&A, the comment section here on WFLA Now.
In Ray Grand Jury. Yeah.
So
we did oral argument react to that
and lawyer
recently. It was a really good case.
Whole emoji out there for you, Peter. I lived in Asheville, North Carolina when this happened. It was big news even there. I'm now in South Carolina. People want this done. How far out, state-wise, can they go to find unbiased jurors? It's a good question.
I don't think they're going outside the state or anything like that. I'm not sure if they're pulling from other counties. I haven't seen where they're pulling all these jurors, but I've heard they have a ton of jurors that they're going to bring through, and that's why it can take days, right? If you keep what we call in jury selection busting.
I'm sorry to hear that,
right? Where too many jurors get struck, there's not enough jurors to even pick 12 plus a couple alternates. Then we need to bring in another panel. Are there going to be 3 jurors that they pick from the first panel? And then they're going to have to go for the second 30 to 50 people, depending on how big the courtroom is.
Will it be difficult to find jurors that haven't heard about this case?
50, sometimes we can have
in this part of the state. Yeah.
But that's why it takes so long.
This has obviously been huge news.
Jurors, which is also why I wouldn't
in
expect
the
to
state,
have a bunch of
and
other
even
trials,
more so in the jurisdiction.
You don't want
so
reject jurors from other trials.
They apparently did 900 jurors.
They're probably going to give this one kind of the first priority.
At least in
jurors that might not know what's going on in this case.
I don't think they actually. I don't think they necessarily pulled 900 jurors.
Yeah, and if I believe it's.
I don't think they necessarily pulled 900 jurors for voir dire, but I think they said they did 900 jurors for the initial written voir dire.
Usually 2 or 4.
Usually you want to have at least 1 per week. So I think this is going to last till February 10th. So maybe that they'll have at least 3 or 4 alternates, something like that.
And then Grizzly True Crime on YouTube Live asking really the big question that everybody wants the answer to. How long will jury selection take? I keep hearing as short as 2 days up till really the entirety of this week with the trial beginning on Monday. What do you think, Peter?
So when you have a pretrial, the judge usually asks, how long do you expect this to take? There are certain things where we know exactly how long it's going to take. How long is your opening statement going to be? 30 to 45 minutes, Judge. How long do you think your case in chief is going to be? 6 days, Judge, because we plan out the witnesses, give or take a day or a half a day, especially the longer the trial is, the more leeway there is. But when it comes to jury selection, a lot of times judges will try to limit what lawyers can do during jury selections. And like I said, that's much different in civil and criminal cases. But in a criminal case like this, I would be surprised if it took less than 2 days. And like you said, it wouldn't surprise
Grizzly
me at all
True
if it took
Crime,
all
good
week,
channel.
or if it took most of the week and they decided to come back the following
Maybe she'll
Monday,
be able
do
to join
opening
me. That'd be
statements
cool.
to give them
I'll
some time to
I'll send her an
prepare.
invite
I'm sure they have
when
some
the
kind of
trial
jury
actually starts happening. Maybe I'll send her
or
an
somebody
invite. That'd be
doing
cool.
research on these jurors in the background as well, giving them some information, and it may take time. They'll do a lot of work overnight as well before they come in the next day. So a lot of work goes into jury selection. It's potentially the most important part of the trial.
Kristen wants to know, do you know if there's going to be a separate trial for the fraud charges? And,
Yes.
And yes, but at a later date, correct, Peter?
Yeah, I think there's like 70 plus charges or something at this point.
The last I heard was around 100, or just
insane.
100 total charges. So there
It's
will
wild.
be.
It's wild.
It's insane. There will be a separate trial, but I want to ask you this: if Alex Murdaugh is found to be not guilty, he still has to answer to nearly 100 or so charges.
103.
Is there any doubt that we're looking at somebody who, I mean, I believe, I'm trying to remember my notes, I believe that Alex Murdaugh is about approximately 64 years old. I mean, is it looking like this is somebody who's going to spend the rest of his life behind bars?
The odds are against him. Okay, I mean, it's going to be very difficult, even if he wins this case, for him to win all the others. I think if he loses this case, the question that keeps popping up is what's going to happen to the others. He's probably a lot more likely to plead, unless he's got some good appellate issues. Then he'll continue fighting those while he appeals this. This is obviously the most serious crime, most serious charges. If he's not guilty here, there's a better chance that he potentially gets some kind of bond or bail so that he can get out pending the other charges and continue to fight them.
Yeah.
A lot is still up in
Greyhound,
the
this
air
is
when you have
just the
this many
double
moving
murders.
parts. From everything I've read, this particular prosecuting attorney
If
is
there's
handling
audio,
all of Alex Murdaugh's
if there's audio,
cases,
I will take
so
audio
he
for
knows
sure.
what's going on in all the other ones as well.
Yeah, and I look forward to hearing more from the prosecution, the defense. I keep hearing that the attorney for
James
Alex
in court
Murdaugh
just
is
tweeted
an
no TV
all-star
video,
type
but
pro,
maybe audio.
in South Carolina, somebody whose name
Check it out on
carries
Twitter.
just a lot of weight as far as the legal system in South Carolina. So this is going to be, is this shaping up to be one of the most, if the not the most high-profile trial?
I'm waiting on the Club
year,
Q shooting
Peter?
trial here. Dude is charged
It's
with
hard to project that type of
177
stuff, right?
charges
A lot of us
currently.
didn't see the Johnny Depp Amber
A lot of
Heard
charges.
Story coming.
Thank you very much,
You can't
Pinking
possibly see
554.
stories like Gabby Petito or the Idaho university students' cases coming. So it's hard to kind of tell what's going to capture the media's attention. But this one has all the makings. And I think when people start hearing, if the judge allows the prosecutor to get into all the other tangential charges and allegations, then I think this could potentially capture the world's view, because they really are going to be surprised when they hear about some of the factors and facts
Right.
and the web that you've been describing that's going on around the Murdaugh
Yeah,
family.
James says there might
So
be
I
an
do
audio
think it has
feed,
that
so we'll
potential for sure.
pay attention.
Tangential charges, Peter Tragos, always enlightening us, and really, but Peter, I'm with you, because that to me, when
Am I in touch with
I
James
was
with court?
taking
Not
notes all
particularly.
yesterday,
But I'll
and
tweet.
the
I'll
big thing
message
that
him
I
back.
circled is just how much of this trial is going to be focused on the murders of Maggie and Paul, with so much other
Just to keep us posted.
this interconnected web of so many other cases that are tied to this one. Is it going to veer off the track, so to speak, or is it going to stay on the track? How much of it is it going to be focused on the actual murder scene, the evidence, the testimony, so on and so forth? I mean, that's something that I keep hearing, that the opening arguments are going to be something to behold, because it's going to really set the stage for what is going to be expected to be about a 3-week trial. So just exactly what this looks like, and if it's as much of a circus as really all the media coverage has been up until this point, it is also a big question as well.
There's no question that you understand a lot more how somebody could be capable morally, ethically, physically, emotionally of committing a crime like this against his own family when you hear about everything else, right? Because you just can't imagine how you can steal money from injured victims, from dead victims, from your own housekeeper, from your own partners that you've been in a working relationship with or in partnership for generations. But when you hear somebody's capable of all that, it's literally propensity evidence that maybe he's capable of this. And that's exactly what the rules of evidence don't want coming into trial. They want this jury determining, did he commit these specific acts and what evidence do you have that he committed these acts? Not that he's a bad person, not that he's a bad guy, not that he has a flawed moral compass, not that he could steal money, not that he doesn't care about victims, not that he doesn't sympathize or have empathy for anybody. Did he commit these acts? That is the question we're supposed to be in court talking about for the next couple weeks. And I think, like you mentioned, his lawyers are very good lawyers, top-notch lawyers, top prosecutors, state and federal level, representing him now on the defense side in this criminal case. So I think that's going to be a big part of their job, is keeping everything else out.
All right, 1,000 viewers. All right, thank you for all 1,009 of you currently watching.
Acts, and I think that's a tough job with all of the other arguments that the prosecutor's trying to make with motive, and this is why he committed these acts, and it shows the jury the full picture, and they are really important for these other reasons, not just for propensity evidence. So that's what I'm really interested in seeing, this back and forth on how much of the web actually comes into this trial, because I think you and I would look at this a lot differently if we just heard, okay, dad is accused of killing mom and kid with 2 separate guns. They don't have a murder weapon. The blood splatter evidence isn't that great. He has an alibi, meaning he wasn't even really there at this time, if we believe the people that are testifying about his alibi. I think we'd be a lot more skeptical if we didn't know about all of the other Alex Murdaugh allegations.
It's to kill your own wife, to shoot and kill your own son on your hunting property, to do so. Motive is also something that I've been doing some research into, what the motive might be. Why would someone—
Thank you very much for the gift memberships, 9-inch
lawyer or
nails gal,
murder their wife and son? What the reason might have been, and proving motive for that is going to be extraordinarily difficult for the prosecution. I know you have to go, Peter, but I'll leave you with that. As far as what you make of the potential motive in this case, and I'll get into it here after you're off stream, but what's your take on it?
The prosecutors made it clear in the last pretrial that they believe the motive is covering up the financial crimes. And now the defense argues that he's going to commit worse crimes to cover up less serious crimes. And the answer is, well, if it would
that's usually how that goes,
they
to be
wouldn't
quite
have found
honest.
out about the worst crimes, meaning the murder. And yes, he was trying to cover up all of the financial crimes that were coming tumbling down on top of him, literally burying him in all of these financial crimes that he's been accused of. So they want to get into all of those other crimes, the fact that he committed all of those other crimes, even though they haven't been proven beyond a reasonable doubt, and to cover them up is the motive of this case. Without that, what's the motive? There's nothing to indicate that he hated his son or hated his wife, or they were fighting, or there was anything like that outside of the normal or the ordinary issues that you have going on in a family. But I think they do have a pretty good motive if they can talk about the financial crimes, especially because, as you mentioned, Paul was involved in that boating accident. Did his wife and did Paul know about some of his theft, some of his financial crimes, some of his fraud? What did they know exactly, I think, is also going to be difficult for the prosecution to prove, because in order for that to be a motive, they would have to prove that they even knew about it, so that killing them would even cover up those financial crimes. And if that is the case, and the defense is forced to argue this motive back and forth, who else potentially could have known about it? His partners, the paralegal that was the one putting some pressure on him about this check that I guess he stole the client's money allegedly. And that's what kind of made it all crumble down. Why didn't he kill her if he was going to try to cover up these financial crimes? So does that really make sense that that's a motive for killing your wife and son? Or is it more
exact
likely
charges
that they're
in
gonna bring up
this
some
are
alternative
murder.
Suspect or some
We got 2 counts of murder,
two
and
guns, two
their
people.
respective
I think
lesser
there's a lot
included.
of potential arguments we could see in the
So
fact that this was a
it's 2
speedy
counts
trial.
of murder with
We
their
really
respective
don't
lesser
know
included, which I'm not exactly
how
sure what
the
they
evidence
are,
is gonna be
but
presented in the case, which is why I think opening statements are going to
assault,
really give us
battery,
a roadmap
manslaughter,
of what we
blah,
can expect to
whatever.
see.
Peter Tragus,
KHM gives
the lawyer,
$20. Thank you very much
your
for the
insight,
super
Peter.
chat. That's
I have
very
a funny
generous.
feeling that I'm going to be talking to you again about this case as things begin to, of course, take shape over the weeks ahead, and as we get closer to really the end of this trial. If you have
Well, the
not
drug
found
charges mentioned in the
his
description,
channel,
I'd have to
Peter
go look
Tragus,
it
the
up.
lawyer
It's
you
so
know,
much
go
stuff.
find
It's
him
hard to
right
keep
now
track
on
of.
YouTube. He's, of course, across other social media platforms. He has joined me now recently as we do some stuff on some other platforms together. Peter, you're a pro.
I'm
Thank you
assuming
so much.
WFLA will
Thanks,
not
man.
copy
Appreciate
strike
it.
me for
Talk
covering
soon,
Peter Trogos.
Talk soon.
Alrighty. Peter Tragos, folks. Yeah.
I was assuming that they will not strike me for covering Peter Trogos because, well, you know, friend of LawTube. I assume they wouldn't strike me for that. So we'll see. But here's what we're going to do. In 10 minutes, the Supreme Court is going to release a opinion or more. So we have some sort of opinion coming down from the U.S. Supreme Court today. I don't know. I don't know what case it is. I don't know how many there are. I do know that it's happening in 10 minutes. And so we will cover that because that will be good. And then what we will do is we will watch the appellate argument for Chauvin because that sounds interesting. And that can be our morning.
Likes to viewers ratio is on point. Happy you're streaming.
Woot. Yeah, 774 likes and 1,079 concurrent viewers. That is really, really awesome. And really, really appreciated by everyone. Thank you very, very much. How far behind is my feed? I'm so confused right now. Okay, whatever. Anyways, we're going to do, thank you, Jojo6178 for the 20 gift memberships. That is incredibly encouraging and appreciated. Thank you. Lord Asserman for $5 asked, do we have any idea how long this case is meant to go? February 10th, I believe, is the date they're saying right now. Pingkin554 said $2. How is Louis Rossman in real life? He's cool. He's a nice guy. He was very kind. He was very nice to me. And he talked to me about some stuff, and maybe there's some opportunities for me coming up in the future. He apparently, for example, has some sort of relationship with Destiny. And so I was like, and people on my channel had previously suggested me talking to Destiny. So I was like, okay, well, can you make an introduction? So maybe we will have Destiny on stream. That could be fun. Who knows? Kimberly Fisher has 4499 said James and Court just tweeted no TV, but maybe audio. If we get audio, we'll be happy to stream that or whatever we can get. Pingkin554 said, I'm just waiting on the Club Q trials here. Dude is charged with 177 charges currently. Samuel Ellers for $10 said, like to viewers ratios on point, happier streaming. 9 Inch Nail Gal said, work is giving me extra shifts. So passing on the love. I miss seeing you live on Friday Night Frenzy when I've been out of state for the last month. Thank you very much for all those very generous super chats. It's very, very kind of you. Did you miss anything? Yeah, we missed an interview with Peter Trigos. Let me refresh something because hold on 1 second. Talk amongst yourselves. Okay. Yeah. For whatever reason, my feed within YouTube was behind, so I just refreshed the feed to myself. Anyways, yeah, we will be talking about. Excuse me. We will do the Supreme Court stuff that's going to come down here, and then we will do the appellate argument for Chauvin because that will be fun. And we will go from there. Solly Rustler, 5 gift memberships. Thank you very, very much. I appreciate that very much for all those gift memberships. I appreciate everyone who helps with gift memberships. Remember, it's only 99 cents a month to help support the channel. Is not his other son in trouble due to working at the law firm too? I don't know about trouble with respect to his other son, to be honest. I don't know that. My emojis won't stay on to use. Jojo says, I really like your channel. Your Supreme Court info is great, and you're covering this case is awesome. Well, we're going to have some Supreme Court stuff in about 5 minutes, give or take. Maybe a little bit longer. Who's this guy on the background? This is some sort of Florida attorney, I believe. WFLA. Well, that probably is a Florida. Or Florida. It's a Florida feed. The other son got kicked out of law school? Yeah. Do I think Chauvin's appeal could be affected by his guilty pleas? No. They're completely independent legal charges. I would imagine he's an anchor, not an attorney. I misspoke. It happens. Jury is still doing questionnaires. Cool. Thanks for letting me know. And if they broadcast any of it, they broadcast audio, they give me any video or anything, we'll obviously cover that too. So we're just trying to cover what we can cover. Probably because he's arrested in Florida and extradited from Florida. Can he use a debit card when purchasing membership? I don't know. I honestly don't know. I mean, if it's a Visa or MasterCard debit card, I would assume so. Listen to, he's giving a rundown of the case.
He's in the area. You could make the argument, people have made the argument that he's well known in good ways. Others have made the argument that he's well known in really bad ways, sinister ways. His reputation carries significant weight and in different ways to different people in South Carolina. He is accused of gunning down his wife and his son there on your screen in June of 2021 at their hunting estate outside the dog kennels. His wife found shot multiple times, including 2 shots to the head while laying on the ground. His son found dead of 2 shotgun blasts. The allegation is that Alex Murdaugh.
To become a member, you either hit the link that the bot tells you about from time to time, or you hit the $sign under the chat, and you can become a member that way.
Schemes that he had been the
so under the chat, there should be a $sign. You can click on that to become a member. You may or may not be able to do it from mobile. And if not, then the bot tells you the link from time to time.
As far as this trial, some trials
I try to make it informative without being spammy, which is an interesting balance to try to make, right? It's like you want to give links to people. You want to give links to people because people are like, well, how can I do this and how can I do that? And so it's like, okay, I'll just set up a script to remind people from time to time. Like people ask, like, how can I become a member? Or how can I connect with you or whatever? It's like, okay, so I'll set up a script. And then it's a nice little balance of how often do I have PayPal? Yes, as a matter of fact, I do. And that is also in the, that is Streamlabs. Although you can do direct to PayPal if you like. It's paypal.me/uncivil law if you want to do that. But yeah, it's all about trying to give the if you do I think it's a exclamation tip gives the information. Let's find out. Let's see, does this work? Put it in the video bio too. It says connect. I think it is in the video bio, to be honest. There's connect with me. No, is it join, become an uncivilian, or is it #donate?
Just wanted to say good morning, and you're awesome. Have a great day.
Yeah, there it is. Exclamation donate. Donate via Streamlabs instead. That's PayPal. And so yeah, and it should be in the video description. There's always like connect with me. If you go to connect with me, it gives you all the links for everything. So I've tried to make it as non-spammy and non-informative as possible. And then of course you just have the bot just give the regular announcement on the clock too. So now I have 2 announcements back to back and it looks spammy. So that's just great news. We do what we can. Yeah. But yeah, if you go to connect with me, go to Linktree link, it should give you everything you need. Every possible way of like supporting the channel and everything. What time does this trial start? Wednesday. Ooh, lol. They're saying that there's one box from the Supreme Court, so like 1 or 2 opinions. So we'll do our 1 or 2 opinions that we have and go from there. Glad to be awake or not working for live stream. I joined on mobile using my debit card. Easy. See, there you go. Jessica says you can do it. So I appreciate it. Right. And we've tried to make it accessible. Right. One of the reasons we made it 99 cents is so that, everyone can afford it. Cause like, when you do all those memberships, it can add up. And I know that. And I appreciate that. So it's like, well, we'll just make it, we'll make it accessible. Am I covering the whole trial? Yes, I am. That is my intent. That is my intention, to cover the whole trial. I've never seen jury selection before. I'm not sure we're going to see it today, to be honest. We saw it, the last time we saw jury selection, I think, was in the Kim Potter case. We saw jury selection for that. All right, let's see. It's 10 o'clock. Veteran benefits case. It's just come down from the U.S. Supreme Court. I believe this deals with dual status, but we'll see when the opinion actually get a link for it, and then I'll share that. So I will, nope, that's not what I wanted to do at all. I want to hide that. And then I'm going to add a new stream, and we will go through some Supreme Court analysis, because that's fun and exciting. We get to learn new law. What do I mean by dual status? There's a case at the U.S. Supreme Court, and I don't know if this is it, where there's a guy who is in the reserves, I think, and there was a question as to his benefits, because it's like, does he get benefits for being, because he was some sort of electrician or something like that, where he might have, because he's a reservist and he's in this, so he might be a federal employee. He might be a federal employee outside of him being a reservist. So he might need compensation both as a reservist and also as this other thing. So there was this guy who might be both. And there was a question as to that. Okay, we have an opinion. We have an opinion, friends. Let's do some Supreme Court opinion. You guys are going to learn things. Lol. You guys are going to learn things. Lol. All right, let me move myself to the side so we can see more of the text. How do I do that? Okay. From a unanimous Supreme Court, from Alorano versus McDonough. This case concerns the effective date of an award of disability compensation to a veteran of the United States military. Approximately 30 years ago, after Adolph Alorino's honorable discharge from the Navy, Alorino applied to the Department of Veteran Affairs for disability compensation based on psychiatric disorders. 30 years ago, or 30 years after he was discharged, apologize, I misread it twice. So 30 years after he was discharged, he applied for disability. Okay, not 30 years ago. I misread it twice. That's all right. We got it right the third time. A VA regional office granted Alorino's service-connected disability benefits after finding that his disorders resulted from trauma he suffered while serving on an aircraft carrier. Applying the default rule in 38 USC 5110 or 5110A1, the VA assigned an effective date of June 3rd, 2011, the day the agency received the claim to the disability award. Okay, so the question is, from what date does the disability roll, I suppose? Alorano appealed, arguing that the effective date should be governed by an exception in B1, which makes the effective date of the award of disability the day following the day of veteran's discharge or release, if application thereof is received within 1 year of such date of discharge or release. Well, it's not within 1 year. So I'm not sure how that works. Right. So, so what this says, apparently, what it says is that you get your award from the date of your claim, unless your claim is within a year of your discharge, in which case we basically roll it back to the date of discharge or the date after discharge. So if you make your claim within a year, we roll it back. If you don't make your claim within a year, we don't roll it back. Okay. That's what that seems to say. Fine. Alleging that he had been too ill to know that he could apply for disability benefits. Alorano maintained that this exception's 1 year grace period should be equitably told to make his award effective on or about the day after discharge in 1981. Okay. So we want benefits for 30 years. We want benefits for 30 years. We want back benefits for 30 years. That's a lot of back benefits. That is a lot of equitable tolling. I just want to say, like, even if this idea makes sense, that is a lot of equitable tolling. So I would be a bit surprised if the Supreme Court says yes, but let's see what they said. The VA Board of Veterans Appeals denied the request, and the Court of Appeals for Veterans Claims affirmed. The federal court affirmed. Held. It's not subject to equitable tolling. Yeah, even if it was, 30 years is a lot of equity. That's a lot of equitable tolling, right? So, yeah. Equitable tolling effectively extends an otherwise discrete limitation period set up by Congress when a litigant diligently pursues his rights, but extraordinary circumstances prevent him from bringing timely action. The court presumes that federal statutes of limitations are subject to equitable tolling, but this presumption is rebutted if equitable tolling is inconsistent with the statutory scheme. Also, like, I don't know that we necessarily need to decide it as like, I don't know that we need to decide it this way, right? It's like 30 years, you didn't know, right? Were you in a coma the whole time, right? It's like, what was preventing you? What was extraordinary that was preventing you, right? So I don't know that we necessarily need this per se rule, but we're going to do per se. That's fine, I suppose. Anyways, this presumption is rebutted if equitable tolling is inconsistent with the statutory scheme. Here, the Secretary of Veterans Affairs argues that B1 is not a statute of limitations, and that even if it were, any applicable presumption in favor of equitable tolling is rebutted by statutory text and structure. The court need not decide whether B1 is a statute of limitations. Even assuming the exception sets a limitation period, which it seems to on its own terms, but okay, there exists good reason to believe that Congress did not want equitable tolling to apply. B1 operates as a limited exception to A1's default rule, which states that the effective date of the award shall be fixed in accordance with facts found, but shall not be earlier than the date of receipt of application. So amazingly enough, you can only get disability benefits from the date of your application, because that's when you let them know that there was a problem. So, you can't get benefits from before then. That's logical. Like, you could have a different logical rule. I'm not saying it's the only logical rule, but it's a logical rule. It's like, okay, you're only going to get benefits from the date you start applying for benefits. Okay. The default rule applies unless specifically provided for otherwise in the chapter. A clause indicating that Congress enumerated an exhaustive list of exemptions, which each confined to specific terms. Accordingly, according to the terms of the exemption in B1, the effective date of the award of disability compensation shall be the day following the date of veteran's discharge or release if application thereof is received within 1 year. So from the date of your application, unless your application was within a year, in which case we'll give it back to the date of discharge. Also logical, right? We could have different rules, but this is a logical rule. And, Congress is entitled to its choices. So it's a logical rule. It makes sense. Other things would make sense, but this makes sense. So go do the thing that Congress said. Makes sense. Equitable tolling told this provision would depart from the terms that Congress specifically provided. The structure, which sets out 16 exceptions that explain when various types of benefits qualify for an effective date earlier than default, reinforces congressional choice. These exceptions do not operate simply as time constraints, but also substantive limitations on the amount of recovery due, a structure strongly indicating that Congress did not intend courts to read other unmentioned, open-ended equitable exemptions in the statute they wrote, that many of the specific exemptions reflect equitable considerations, heightened structural inference, as does the fact that Congress generally capped retroactive benefits roughly at a year. So some of these 16 exceptions are rooted in equity. But that is more the reason to believe that Congress meant to constrain it, not expand it, right? So Congress, this is statutory construction. This is just statutory construction, right? This is not a constitutional law case. This is a statutory construction case. So Congress can overrule this decision, incidentally, just for whatever it's worth. Can Congress overrule the Supreme Court? Sure, when it's statutory, which this is. So Congress can overrule the Supreme Court. In fact, they can even overrule them retroactively if they wanted to, because it's a statute, right? Congress can say, no, that's not what we meant. And also, incidentally, we're reversing ourselves backwards and we're giving him money. Yay, money, right? So if this is not what Congress wants, Congress can change it. But what they're saying is, well, Congress said, okay, you only get payment from the date of your application. Logical. Then they said, here are 16 exceptions that apply. And some of those exceptions are rooted in equitable considerations. So Congress was certainly aware of equity when it was considering its statutory scheme. And it said, okay, we are going to build in these equitable exceptions. Great. That's all the more reason to believe there's not some sort of free-floating equitable exception. Because Congress seems to have thought of everything. 16 is a lot of exceptions. That's a lot of things. So, no. Thank you. Thank you for your super chat. A few days past a year, sure, I can understand, but 3 whole decades? Yeah, this is the problem, right? It's I don't know necessarily that we need to make this decision this way. We could just simply say that he did not in reality preserve it without deciding the issue. On the facts, we could decide this on the facts rather than the statute would be another way to get to this, right? So it's even assuming equity, not for you. That would be probably my inclination of how to write this, right? So even assuming equity, not for you. But the court wants to go to the next step of, okay, not equity. Which, they want to decide the issue. Which, fair enough. It's one of the prerogatives of the Supreme Court. When, as here, Congress has already considered equitable concerns and limited relief available, additional equitable tolling would be unwarranted. Although hard and fast limits on retroactive benefits can create harsh results, Congress has the power to choose between rules, which prioritize efficiency and predictability, and standards which prioritize optimal results. So, Congress can choose things that are stricter or more free-floating or whatever, and those choices are choices with their respective benefits and trade-offs. And Congress seems to have come up with a fairly comprehensive scheme. So, Congress opted for rules in the statutory scheme when equitable extension of the grace period that would disrupt the choice. Alorano over here sees B1 as a simple time limit, and therefore a classic case for equitable tolling. Even if that's true, not so much for you. 3 decades? Really? But B1 cannot be understood independently of A1, which makes the date of claim of receipt the effective date unless specifically provided for otherwise in this chapter. This language is an instruction to attend to specifically enacted language to the exclusion of general unenacted carve-outs. Alorano relies on a specific exemption in B4, which makes disability pension benefits retroactive in certain cases where permanent and total disability prevents a veteran from applying for an award at the time of disability onset, to argue that Congress wanted traditional principles of equitable tolling to apply. That's bullshit. If you fall into B4, then great. But if not, then Congress wanted some generalized thing. No, they wanted B4. That's why they wrote it. To the contrary, B4 demonstrates that Congress had on its radar the possibility that disability could delay an application for benefits, and still Congress did not explicitly account for the possibility in B1. Finally, Alorano contends the nature of the subject matter, veterans' benefits. Counsel's in favor of tolling because providing benefits to veterans is a context in which individual equities are paramount. But the nature of the subject matter cannot overcome statutory text and structure. Barrett delivers opinion for a unanimous Supreme Court. Unsurprisingly. So you can't get your 30 years worth of benefits. That's ridiculous. Do they have, what is this? Ooh, in re grand jury. Whoa. Wow. Okay. We have a decision in re grand jury. The oral argument that we just had. In re grand jury, per curum, the writ of certiorari is dismissed as improvidently granted. Well, that happened. Okay. So remember that oral argument in re grand jury? No, you don't, because it never happened. Okay. Well, that was that. Great. And that appears to be all the decisions for the day. So, okay. What does in re grand jury mean? It was the name of the case. It was the name of the case. There was a case dealing with attorney-client privilege and its scope. And no, not jurisdiction. They dismissed it as improvidently granted. They decided that they shouldn't have heard the case. So, okay. Well, that's that. Yeah. I hate it when they do stuff like that. Brief it, prep, argue. Oops, we didn't mean to say yes. It is a little frustrating. It is a little frustrating. So the lower court decision stands. That's right. That's exactly correct. It's like the Supreme Court never grants certiorari at all. Supreme Court? What Supreme Court? Never heard of it. Yeah. So I suppose that means that the law firm is in contempt. So that sucks. So that means that they have to give over all those records if they haven't already, because they lost all their appeals. So that means there is no attorney-client privilege in this context. I don't know. Was that the one with the annoying orator? That would be the very one. Yeah. Yeah, when they do a dig, it's like the case never got to them. That's exactly right. It's like they never granted certiorari. It's like they said no. It's a retroactive no. The Supreme Court in New York is a different court. In New York, the Supreme Court is the trial court. So it's a very confusingly named thing. All right, what's going on here? Let's listen to a little bit of this, and then we're going to go back to... Okay, there's nothing to listen to. The state of Maryland just renamed its courts. So now the Supreme Court in Maryland is the Supreme Court of Maryland. So Maryland just renamed its courts because of this exact confusion issue. Okay, there's a DM on Twitter with an update. Let me take a look. Thank you. Let's see. judge decided no cameras or live updated on jury selection. No one is allowed to stream, including court TV. Murdaugh attorneys filed 30-page motions regarding blood splatter analysis. Okay. Well, let's do something productive with our time. Let's watch the appeal of anything for Selena said, just wanted to say good morning. You're awesome. Have a great day. Jessica B gave $2. Thank you, Jessica B/Jessica Fish, for your kind super chat. Joined in using my debit card, easy. And Nine Inch Nails gal commented super chat, a few days past a year. Sure, I can understand that, but nearly 3 whole decades. Dude is just dreaming. Yeah, and I agree completely. Thank you very much for your kind super chats. Yeah, whatever. All right, let's do the appeal of Chauvin. Hey, Grizzly True Crime. I'm glad to see you here, by the way. By the way, Grizzly True Crime, if you want to join me for the live stream when they actually start doing the trial, let me know. I'd be happy to have you on. I'll send you a link and all the rest of it. But since there's not, I mean, if you want to join now, I mean, I'm looking to kill time. So, because we could talk about the case a little bit. So if you want to join now, I'll send you a link. Do you want to join now? Do you want to wait till the trial starts? What's your pleasure? While Grizzly True Crime is considering her options and whether or not she likes me at all, let's turn our attention to the appeal for Chauvin. Let's see. Okay, 43 minutes of appeal arguments. Excellent. This is for being cool and tolerating my weird sense of humor. I do what I can. I do what I can. Thank you for your super chat. All right. So
This is for being cool and tolerating my weird sense of humor.
So this is the appeal of Derek Chauvin in state court relating to the death of George Floyd. I'm not sure what, I think he's appealing on the media exposure and like tainting the jury, but good luck. Do I want to pin a comment or show a banner informing people what's going on? This is different than the title of a stream. Sure. How would I write that? Jury selection underway in Murdaugh.
Hey Kurt, hope you are having a good day. Are you
Thank you.
planning on doing any coverage for the DWV Crowder situation? Even Shadiversity is getting in on it.
I probably should. I probably should just do a thing today, just talking about it, because people want to have something about it. So maybe I will say something about it. But my opinion is nuanced and somewhat balanced and somewhat like, you know. Let's see. Oh, up next, Chauvin appeal. That works. So that works good. Let's see. Yeah, I'll just pin Trisha's comment. Why complicate my life? There you go. Why complicate my life? All right, that works. All right, so this is the appeal of Derek Chauvin in relating to George Floyd. I believe he's appealing on the grounds of the media exposure basically tainting his case, and good effing luck to all that. The background matches my shirt. I thought it was nice. Yeah, so let's see what's happening in this appeal.
The Minnesota Court of Appeals is now in session. Judge Reyes, Judge Larson, Judge Klophocky. The Honorable Peter M. Reyes, Jr. presiding.
Good morning. You may be seated. Welcome, everyone, to the Minnesota Court of Appeals. Today is Wednesday, January 18th, 2023. We have 6 cases on our calendar today. 4 are set for oral argument. The first of which is A21-1228, State of Minnesota versus Derek Michael Chauvin. Counsel for appellant that's seated to my left here. You will have 15 minutes for your initial arguments, and counsel for respondent, you'll have 15 minutes for your arguments. Counsel for appellant, you will have 5 minutes after that for rebuttal if you so choose. We have the podium in the middle. There is a button on the lower part to lower and raise the podium, and you can also adjust the microphone. There is a timer there. Please be mindful of the amount of time that you have to stay within your time limits. We are allowing this to be live streamed and to be recorded. However, no other recordings are allowed, and we will be recording the audio version of this hearing as well. That will be available within a few days for counsel. Also, counsel, when you approach the podium, please state your name.
Their cameraman is having fun. How old is this appellate judge? I mean, no disrespect, but damn. She's on the court of, how old is she? Shit. How am I not on the Court of Appeals? Damn.
Be splitting any time within any
Is this a mock trial or the real thing? Holy shit.
other counsel at all. I'm sorry, Your Honor. Yes, will counsel for either party be splitting time with anyone else? No, Your Honor. No, Your Honor. Okay, thank you very much. With that, counsel for
Also, is she single?
appellant, you may approach the podium and begin your arguments.
So take your daughter to work day? Is it kids react? Is this what? WFLA has audio of the jury selection, do they? Hold on. Gripping content right now. Gripping content. This is the best content. All right, I'm going back to the Chauvin argument.
Good morning, Your Honors. My name is William Mormon. I represent appellant Derek Chauvin. May it please the court, counsel. I do want to note, unfortunately, before I begin my argument, I had an oral argument before the Court of Appeals last week, and it wasn't a big problem in that courtroom, but it is here. 8 years ago, I lost my hearing in my left ear. So I've got single-sided deafness that may cause some issues hearing things. In addition, when two people are talking, and that can include myself, it all turns into a jumble. So if the court asks me a question in the middle of my argument, which is of course legitimate, I may ask you to repeat it.
Not a problem. Feel free to let us know at any time, and we'll make sure to try to speak up as loudly as possible to make sure. But please let us know if you have any issues at all.
I will, and you'll often see me when you talk tilting my head this way, and that's to direct my ear towards you. The primary issue on this appeal is whether a criminal defendant can get a fair trial consistent with constitutional requirements in a courthouse that's surrounded by concrete block, barbed wire, 2 armored personnel carriers, and a squad of National Guard troops, all of which are there for one purpose: in the event that the jury acquits the defendant. I want to begin my argument today, and most of my argument today, focusing on the issue constitution.
I like the way he starts the argument, though. I like the way he starts the argument. I like the use of the imagery. I like him painting the picture with the barbed wire and the riot things and stuff. It's like, can they get a fair trial when, like, this is what happens if they're acquitted? So regardless of him winning, and which he totally will not, but I like the way he starts it. I like the use of the imagery, painting the picture, and I also like its brevity. He didn't say too much. It was short. It was short, to the point, clear, illustrative. It was a nice thing, and I don't think it was too much either, right? Because you could overinflate the imagery and like make it too what would you say? You could make it sound more dire than it is. You could make it sound worse than it is. Like, you could really amp up the adjectives and stuff like that to really make it sound more to make it sound more, and like it be too much, like being too clever by half. And I don't think he did that. I think he stayed nicely within the bounds. Maybe a touch much, but it's like, at that point I'm talking nuances, right? It's like, maybe it's a touch much, but at that point I'm critiquing it like I am, a judge at a cooking competition and saying like, oh, there's just a pinch too much salt in this. Like, I'm really like tilting at windmills. But I like the overall thrust of the opening. I thought that was good work.
Issue of the pervasiveness of the pretrial publicity in this case, combined with a factor that's not often found.
Clippies, we'll go back to long crime. We'll go back to long crime for the live audio after this. I don't want to go back and forth. We are not missing much. We'll go back to the oral argument or go back to the thing. I want to do this for now, if you don't mind.
In cases regarding a fair trial, and that's physical pressure on the courthouse and the courthouse participants.
Counsel, I understand that you want to address that issue, and I certainly want to discuss that one. But before we get to that issue, there's one other I wanted to talk about briefly, and that's with respect to the Schwartz hearing.
Yes.
And would you agree that with respect to jury questioning, that Chauvin had the opportunity to question all of the jurors, including Juror 52?
Yes.
Okay. Would you agree that the district court has, under case law, fairly broad discretion on whether to grant or deny a request for a Schwartz hearing?
Yes.
Okay. And would you agree that case law also recognizes that a district court does not abuse its fairly broad discretion when a defendant has an opportunity to question a juror, even if there is a basis to hold a hearing?
That I don't agree with, because in this case the juror answered juror questionnaires falsely that were directly relevant to the issues in the case with ferreting out potential juror bias.
But that's a fairly accurate paraphrase from the Stofflet case, that A district court does not abuse its broad discretion when a defendant has an opportunity to question a juror, even if there is a basis to hold a hearing. In other words, we give fairly broad discretion to the district court in terms of its decisions.
That's true. I think there's an exception when you get a false question to a jury questionnaire. I mean, there were four items we pointed out in our brief. The most important one to me is the questionnaire asked whether or not the participants had attended any kind of rallies or protests related to police brutality, and juror 52 attended the rally in Washington.
I don't think rally was the word that was used in that question for the juror. I think the question was protests. Yes. And even in Chauvin's briefing below, as well as the briefing to this court, it identified and referred to that as a march, the event in Washington as a march. And there were specific questions that were asked, but in terms of protests in Minneapolis, and he answered no, which was truthful. He didn't.
That's correct.
Yeah. But the question on protests, the broad question on protests did not include the word march. And even Chauvin appeared to acknowledge that that was a march. It wasn't a protest.
I don't see in the context of this case the difference between those two items.
Well, I think it is. Your briefing seems to acknowledge that there is a difference because those two words were not used synonymously. So I don't see how that testimony is false. If
I think in terms of a juror questionnaire, the juror questionnaire would get quite lengthy and wordy if you had to tease out every word like that.
That's what voir dire is for, though, to be able to expand on the questionnaires and ask those probing questions. And case law is clear that the burden for asking those probing questions is on the defendant.
I understand that. I still think in the context of this case, the juror was not forthright in answering that question, yes, and acknowledging that he had attended a rally, protest, march, whatever in Washington that was directly connected to this case. I'm sorry, have I?
No, go ahead.
You seem to want to ask another question on this.
No, go ahead.
Okay.
Before we leave the Schwartz hearing issue, assuming we agree that the trial court should have held a Schwartz hearing, what would you propose that we do with this appeal?
That the case be remanded to the court to hold a Schwartz hearing, and that the district court then make decisions based on the Schwartz hearing.
With the rest of the items of your appeal?
I'm sorry, Your Honor.
How do we handle the rest of the items of your appeal then? We wait until there's a Schwartz hearing, or we decide those questions and then expect a Schwartz hearing?
No, you can decide, you certainly can decide the change of venue issue without deciding the Schwartz hearing. I don't see the Schwartz hearing appeal as blocking this court from ruling on the change of venue issue at all. Have I responded to your question, Your Honor?
That's not the only item you've raised on appeal.
No.
What do we do with the rest of the issues? The question is it appropriate that we then remand for a Schwartz hearing and continue this appeal, or decide the questions that we can and then order a Schwartz hearing? Clear what you're saying.
If the court rules in my favor, or my client's favor, on the other issues we've raised on appeal, that means there's going to have to be a new trial. At that point, I don't think we need to have a Schwartz hearing, because the main remedy my client's looking for here is a new trial.
But before you get to new trial, you have to have a Schwartz hearing first, don't you?
Not if you rule in my, I think Judge Klapiecki was asking me what happens with the other issues related to the Schwartz hearing. If the court concludes that the other issues that Appellant Chauvin has appealed from in this case, that he's correct in those, then the remand back to the district court is to hold a new trial, or on the change of venue issue to remand to the district court to determine a new venue and a new trial's held. And then you don't need a Schwartz hearing. The whole purpose of a Schwartz hearing is to ferret out if the guilty verdict in the case that's before you was tainted by juror misconduct, and then to go back in a Schwartz hearing and figure that out, and then the remedy from that will be to have a new trial.
And for the Schwartz hearing, the only issue that was raised below, was the only issue with the Schwartz hearing raised below the March on Washington?
No, there were four issues related to the juror questionnaire, including, as you cited, whether anybody attended a rally in Minneapolis, whether anyone had negative feelings about the Minneapolis Police Department, and the kind of a res gesti question at the end. Is there anything else that the court should be aware of?
Where in the record were those issues raised to the district court? It appeared that the only one that was actually raised to the district court was the one on the March on Washington.
I believe the one was raised also with the police department, but I don't have the exact citation with me right now to that.
But juror 52 had been questioned extensively on those issues, including what he thought of Black Lives Matters, what he thought of Blue Lives Matters. So he had been thoroughly questioned on those issues, correct?
He had been questioned by counsel on the issues, correct?
And answered very straightforward that he thought Black Lives Matters was important.
That's correct.
That black and racially and ethnically diverse people were not necessarily treated fairly by the police. He thought that Blue Lives Matters was a response to the Black Lives Matter. So he seemed pretty forthright on all those issues. So why, I'm having a hard time understanding how he was not forthright at all in terms of answering any of the questions.
Because if he would have revealed the issues about the march, rally, protest in Washington, it would have prompted other questions from counsel.
Which goes back to, isn't it counsel's duty to ferret out those questions and ask those probing questions?
And what I would say, you're kind of identifying a chicken-egg thing. And I think if jurors are not fully forthright in the juror questionnaire, then it's not possible for counsel to know to inquire into those areas in need.
Good answer.
Which goes back to the standard of review that we have, which is very deferential. We're only an error-correcting court, and we give great deference to the district court's discretion, which here is very broad, to deny it even if there are reasons, if there is an opportunity by the defendant to ask those questions.
Yes.
Okay, thank you.
So, I want to get back to the, obviously, to the pretrial publicity and pressure on the courthouse issue. As we laid out in our papers, the court's to engage in a two-stage analysis or two-tier analysis regarding changing venue. And under the first tier, the court's to determine from the totality of the circumstances whether or not the pretrial publicity or any other factors are such that prejudice is presumed in the jury pool in the community where the case is going to be tried. And then after clearing that issue, you go to the second issue, which is to determine whether or not there was any actual prejudice. Our primary argument here is that this case could not be tried in Minneapolis because of the pretrial publicity, which was pervasive from Memorial Day onward through the trial, and also just the physical pressure on the courthouse. I've laid out in our brief the amount of concerns that the jurors had for their safety. That was all articulated to the judge during voir dire. In fact, Judge Cale acknowledged a number of times on the record that all the jurors had expressed concerns regarding their own safety. With regard to the trial itself, I believe it was 5 days before closing arguments, the governor ordered the deployment of the National Guard throughout the city. And that deployment again was ordered because of the upcoming verdict and the concern that if there was an acquittal, there could be riots again. And under the case law that we've cited, I think what makes this case really unique is again the riots that occurred. Because there's a few few cases. We cited two in our briefing to the court where you had courts either order a change of venue in the Lozano case or in the Nevers case, which was a habeas petition. The court released a police officer who was tried regarding an incident that occurred in Detroit, where the court laid out that the jury was, the court put it bracing for a riot, and that you can't hold a trial in a community where the jurors are looking at the possibility of a riot in the event that the jurors would acquit the defendant.
Has the Minnesota appellate case?
The change of venue argument is pretty strong because of what's happening. Like the juror thing is kind of weak. The change of venue though is looking a little bit better, like because of what was happening, that this was just an inappropriate venue for the thing. That's a better argument. Because the juror, like, did he lie? Did he not lie? Like, you don't want to get into the weeds of the thing. Like, is there a difference between a march and a protest? Probably. I mean, you know, I guess you could get into what is a march. You get into semantics, like, on things like, is the Thanksgiving Day parade a march? If you have a marching band, is that a march? Like, because not all marches are protests, right? So you can have a marching band and, like, you know, heroes welcome. Is that a march? Probably. Is it a protest? Probably not. So is there a difference between a march and a protest? Probably. Are they synonymous? Probably not. So did he lie? Did he not lie? It's like, you know, getting into that issue. And like also, the judge should have held this hearing. It's an abuse of discretion standard. That's hard. But on the venue issue, abuse of discretion is a little bit easier because, well, it was so obvious that this was a bad venue because of all the problems that were present. So yeah, the change of venue is not bad.
Appellate court ever in Minnesota ordered a new trial based upon presumptive prejudicial pretrial publicity?
I couldn't find a case that did, Your Honor, and the state has argued extensively in the response brief that this two-tiered analysis I've laid out under federal law, under the federal Constitution, somehow doesn't hold in Minnesota. I was very concerned about that issue being raised here today, and in preparing for oral argument, I got onto Westlaw and went searching around for what I could find, and there was a treatise, criminal practice manual. It's called Standard Criminal Practice Manual. At section 33.3 discusses this presumption of prejudice issue. And the treatise said some courts have suggested.
Yeah, we'll get back into the jury selection. It's just that when we made the decision to cover this, there was no audio, and now there's audio, and now I have to make the decision of like, do I bail out on this and go back, right? Because it's like, well, you know, so we're here. It's like, I don't know what to do. I think the right thing to do is finish this off and then go back. So we'll finish this argument. It's only going to be a half hour, so we'll go back.
That the moving party bears the burden of demonstrating actual prejudice by adverse publicity, and then it cites for
first and last says, dude, it's a political march. Okay, but does that mean it's a protest? Are all political marches necessarily protests? And I think the answer to that question is probably no, too. Like, can you have a march that's not a protest? Can you have a political march that's not a protest? Yeah, I think so. It's like, you know, I don't think they're necessarily a protest. You could have a march for non-protest reasons. Yeah, I think there's, yeah.
example, State v. Wazaco, 269 Northwest 2nd, 373 Minnesota, 1978. The treatise then continues by stating, although the viability of this view is questionable in light of the decisions by the U.S. Supreme Court in Estes v. Texas and Shepard v. Maxwell. My argument here is I would agree with you. From looking at the Minnesota decisions, they seem to imply that even if you have this presumption of prejudice under the federal Constitution, that there's still a requirement to prove actual prejudice. And that's just contrary to the federal court decisions.
Aren't those federal court decisions?
I'm sorry?
Don't those federal court decisions discuss
They do, because
When I look at the record here, I'm not observing that kind of quote, carnival atmosphere.
Really?
the test under those cases is a totality of the circumstances. So the one case you're describing was the Shepard case where there was a carnival atmosphere. The courts were, for instance, the 4 factors that were discussed in Skilling were non-exclusive factors. The distinction in this case is there's no other case I've seen where there have been the riots such as we had in Minneapolis prior to the trial of this case, coupled with the extensive security at the courthouse. I've got a red light on.
Yes, and you will have 5 minutes for rebuttal.
Thank you.
Thank you, counsel. Counsel for respondent, you also will have 15 minutes for your arguments. Please state your name for the record and the party you are representing, and you may begin when you are ready.
Thank you, Judge Reyes, and may it please the court, Neil Katyal for the state of Minnesota. The evidence at trial showed that on May 25th, 2020, George Floyd died at the hands of 4 police officers. Defendant Derek Chauvin pressed his knees into Floyd's neck and back. Another officer knelt on Floyd's back and held his handcuffed arms. A third restrained his legs. And a fourth held back onlookers who begged the officers to stop. Together, they pushed Floyd down onto the unyielding pavement for 9 minutes and 29 seconds.
Okay, he was doing fine except for the 929 thing. I could have done without the mention of that thing because it's like at this point it's just like a Pavlovian response. 929. It's like But otherwise, the imagery was great right up until he mentioned the time, and then I just like had a conniption because it's like
9 minutes, 29 seconds.
You said it twice. No.
Fled with Chauvin, saying over 25 times, "I can't breathe." At no point did Chauvin provide Floyd any medical care, even after Floyd stopped breathing and moving, and even after Officer King told Chauvin that Floyd didn't have a pulse.
When did he tell him that, counsel?
Excuse me?
When did he tell him that?
In the course of the events, it's about, I think, about 5 to 6 minutes in.
Okay,
and still no medical assistance was rendered. What followed, Your Honor, was one of the most transparent and thorough trials in our nation's history. The court and parties painstakingly selected a jury over 2 weeks. 44 witnesses testified. Jurors watched video footage and heard from bystanders. They learned Chauvin was trained against prone restraints because of positional asphyxia, which is the very thing that killed Floyd. And the jury found Floyd guilty on all.
You can barely hear them? Really? It's very loud in my ear. Is it not loud in your ear?
Counts. Now, Chauvin's many arguments before this court do not come close to justifying reversal. There was no abuse of discretion nor actual prejudice, and to the contrary, Judge Cahill managed this trial with enormous care, and even if Chauvin could identify some minor fault, any error is harmless. The evidence of Chauvin's guilt was captured on video for the world to see. I'd like to start with where the court did the Schwartz hearing. Now, I acknowledge my opponent said that that wasn't the primary issue before the court, but since it's where the court started, I'd like to make 5 points about it. First, Chauvin forfeited this argument before this court and before the district court, and he has to run the table on forfeiture because we're going to be in the land of abuse of discretion, as Your Honor was saying, and indeed plain error review. In the context of Schwartz hearings, he has a special obligation to raise this at the earliest opportunity. And as Judge Reyes, you pointed out, Chauvin had an opportunity to question Juror 52 during voir dire. Indeed, an extensive opportunity. The transcript reveals 35 pages of questions to Juror 52 during the voir dire, a very extensive process. And as Judge Reyes, you were saying, it's not as if Juror 52 was some sort of closeted Trojan horse that was, designed to, trying to hide his views. He was as forthright as possible, time and again, about his views that he had seen police brutality. He believed that the police department discriminated, and that he thought this was a historic case and wanted to be on it. At the same time, he also said he could render an impartial verdict that some of his friends were police officers and law enforcement officers, and the defense made the strategic choice not to strike him. Indeed, they were left with 3 strikes at the end, 3 unused peremptories. Judge Cahill gave 18 peremptories to the defense. Normally, he'd be entitled to 5. 3 of them were left unused. The Warren case says that's a very good indicia that they were satisfied with the claims made, with Juror 52. Now, my friend said, my opponent says that he made many of these claims before the district court, but Judge Reyes, you're absolutely right. The claim that was made before the district court for as to why Juror 52 lied was a claim about whether he had attended any protests in Minneapolis. And obviously, there's no evidence that he did. And that's why I think Judge Cahill denied the Schwartz hearing. So that's the first point. The second is, I think my opponent ignores the procedural posture here. The question is not, would a Schwartz hearing have been a good idea or something like that? You're not independently asking that. You're rather asking the question on appeal, which is, was it an abuse of discretion not to have the Schwartz hearing? And there is deference, very strong deference, given to the trial court. That is what the Benedict case says, and as well, Your Honor, Judge Reyes, what you were pointing out, the Stofel case says that as well. The third thing is that I think my opponent's brief misstates the law about Larson, because they quote one sentence from Larson which says that they can make a prima facie case, but then it goes on to say that the state can rebut that prima facie case, and only if a juror has quote necessarily lied do you get a Schwartz hearing. And with respect to the question that they are isolating, was there a protest in Minneapolis that you attended? There's no claim that he necessarily lied. And most, I think, the evidence shows an honest mistake. I mean, Juror 52 wasn't trying to hide the ball or anything like that. He was very clear about his views of police brutality and racism, as I said. And the standard for a Schwartz hearing is that he had to have necessarily lied, which I don't think they come close to doing. And it's also important to remember that Juror 52's own explanations in the media stories that they point to explain he didn't lie. The Juror 52 said, quote, it was 100% not a march for Floyd, that it was the 57th anniversary of the MLK anniversary. He said he, quote, did not attend the protest on behalf of George Floyd. When asked whether this could be interpreted as a protest related to Floyd, he said, not even close, not even close. And,
Counsel, you would acknowledge, though, that there were people who were discussing, advocating, and speaking on the death of George Floyd and this particular case here, correct?
Sure, Your Honor, absolutely, but I don't think that makes it a necessary lie. And I think the reason why that question is on the questionnaire, which was formulated with input from both sides, is because you're trying to ferret out someone's attitudes as a juror. Are you trying to see, do they have some sort of bias or predisposition to rule a certain way? And here, Juror 52 was as forthright as one could imagine. If you look at our brief at page 27, it recounts the statements made during the voir dire as well as in the questionnaire, all about how he thinks the police are abusive and so on. But what he also says, and he's asked 7 times about this, can you render an impartial verdict? And he says yes. And indeed, one of the questions by my adversary is to Juror 52 is, well, what about all these protests? Can you still render a fair verdict? And he says, absolutely. The protests are very different things than the facts of this specific case. So they've made a strategic choice to leave Juror 52 on at a point when they still have unused peremptories. And I don't think now they can bait and switch and say, well, you know, we got it wrong, and, you know, Juror 52, we should have a Schwartz hearing. As Judge Reyes, your first question to my adversary was, you had the opportunity at voir dire to follow up, particularly when you have these extensive answers that say he believes the police are racist, he's seen incidences of police abuse and the like.
Assuming we might disagree with you, how do you propose that we would handle a remand for a Schwartz hearing?
Yeah, I think you would remand for only the Schwartz hearing and nothing else. I'd caution the court very strongly against that, because if you do that here, then you're going to have it in every high-profile case. Remember, Your Honor, the Minnesota Supreme Court in the Larson case said that you have to be careful about accusations against jurors, and this was before an age of social media. I mean, if what they've done here, this kind of sandbagging is permitted, in every high-profile case, the defense, after a guilty verdict, will scrutinize the jurors' Twitter, Facebook, social media.
I appreciate that argument. My query is more to what do we do with the rest of the issues on appeal?
Yeah, so I think you wouldn't necessarily have to decide them. I think you could just remand for the Schwartz hearing and leave those to another day. We do think the other issues are so clear, you might as well just decide them now. I'm happy to turn to the other issue he focused on, venue, but I'm also happy to answer any other Schwartz questions first.
Actually, I have a different question on the cumulative testimony. You know, 7 witnesses testify. Why isn't that piling on? Why isn't that considered cumulative?
Well, I think the judge has massive discretion there, and as we say, the State versus Bobo case says that for the central issues in a case, there isn't any such thing as cumulative testimony, and here, reasonable use of force was the central issue in the case.
Really? There's a case that says that for a central issue, there's no such thing as cumulative? Really? That's case law? That's odd. Okay.
Sorry, can you state that again in terms of what case are you talking about?
State versus Bobo. It is cited in our brief, Your Honor. It's a Minnesota Supreme Court case, and it basically says, you know, for central issues, there's a different standard for what is cumulative and what isn't. We also don't think that it would be reversible error under any circumstance, because cumulative just simply means that's more additional evidence. There's no case that says you would reverse or something because of the presentation of cumulative testimony, and that's particularly so here because.
What? So from his framework, you can never reverse for cumulative? So the cumulative argument is dead? That seems to be what he's arguing. He seems to be arguing that cumulative is dead. Okay.
Each of the 7 witnesses testified from a different perspective. And remember, the defense was trying to pick off each of these witnesses, attacking them. They said, for example, Chief Arredondo was just a desk officer, an administrator. He hadn't been in the field. And they said, you know, another witness was a national standards expert and wasn't relevant, even though this court's decision in Noor permitted it. So they were trying to attack each one of these, and that's why we as the state did present a comprehensive picture to the jury of this central issue in the case.
Well, you also argued in your brief that you thought that any effect of it would be cumulative. Any cumulative effect would be harmless, and you cited the McDonald-Richards case, but I'm not sure I read that case the same way that you do. I don't think it analyzed whether evidence was objected to as cumulative, but whether the error was inadmissible as an inadmissible statement was harmless because it was cumulative of other evidence. That's a different standard than what we have here.
We quite agree with that, Your Honor. I think our point is that Rule 403's prohibition on cumulative testimony, it's really about efficiency concerns, and there aren't cases that say that you reverse because of the presentation of cumulative evidence. And we'd also point out
it's about efficiency concerns, so there is no due process issue. Cumulative is merely for the convenience of the court.
out here that Judge Cahill was very solicitous of the concerns about cumulative testimony and indeed restricted our ability to use these witnesses because of that concern. So I think what Judge Cahill did was absolutely in the heartland of what trial court discretion is all about. You'd really have to find an abuse of discretion for the first time on cumulative testimony. And here, again, each of the witnesses testified for a distinct perspective and in a circumstance in which the defense was trying to pick off each of the different witnesses, saying that they weren't qualified or something like that, and so that's why we decided to present that full picture to the jury on that central issue.
Counsel, appellant cites to a lot of the case law related to having too many expert witnesses. Could you clarify for me how many of these witnesses were called as expert witnesses and how many were called as fact witnesses?
I believe that there were 7 witnesses called, and the one case that they cite, Deshay, I don't think comes close to saying what they are saying. That was
You didn't
about
answer the
main
question.
Witness that was testifying, and indeed at page 888, the court says that expert testimony, quote, may add precision or depth to the jury's ability to reach conclusions about matters that are not within their experience. And indeed, the bottom line of Deshay is very much supportive of our position. If I could just say a few words about venue, because that is our argument that my friends wanted to start with. And I'd say 5 things. First is that they don't meet the standard, as Judge Reyes, you were suggesting, of clear abuse of discretion and actual prejudice. Presumed prejudice has almost never happened. Your Honor, as you were saying, the one example is Shepard. And in Shepard, what the U.S. Supreme Court said is even in that Bedlam proceeding, if a trial judge managed it correctly through voir dire and through instructions to the jury, even with that Bedlam, that would have been permissible. Here, the district court used extensive procedures for a fair trial. The jury questionnaires, individual voir dire lasting 2 weeks. The Skilling case, the U.S. Supreme Court held it with a 5-hour voir dire in a far more carnival-like atmosphere than the one that was going on in this case. There were 18 strikes given to them. The Warren case says, on venue challenges, if you have unused strikes left at the end, that's a very good indicia that the defense was happy with the jury. And most importantly, they never deal with what we say at page 16 of our brief and the 3 Minnesota Supreme Court cases, Blum and Parker, and Thompson, which say the relevant question is not was there kind of security concern or pretrial publicity in one area. If that pretrial publicity was going to blanket the state, then there is no advantage to shifting venue. And here, Judge Cahill specifically answered what you heard today about the security concerns and the barbed wire and the like. What he said is, and this is quoted in our brief at page 16, that having the trial at the Hennepin County Government Center would be safer and reassure the jury and make them more impartial, not less, because the security could be folded into a general security over the city. And even if you had trial in some other place in Minnesota in a smaller venue, he said the security would stand out and you'd have the same fears of civil unrest there. And so he's made all of those findings on the record at document 192 at pages 4 to 5.
Counsel, I have one more question that I'd like you to address briefly, and that is whether a police officer can be convicted of a second-degree felony murder involving the predicate felony of third-degree assault and discuss reasonable force as well as whether or not that creates a strict liability, which is, I believe, appellant's argument.
Yes, absolutely. So that argument will be reviewed on plain error. It's not an argument that they made below, and we think that that kind of 007 license to kill idea is absurd, because even if you spotted everything in their legal argument about how police officers generally couldn't be guilty of felony murder, here Chauvin acted with special danger to the individual, the jury found.
The special danger, I mean, that goes to appellant's argument, though, that there should have been a jury instruction, which the district court denied. Are you saying that the district court did abuse its discretion then by denying the request for special danger jury instruction?
No, the district court did everything right. There's no need for an instruction because the Minnesota Supreme Court on 2 different occasions in the Anderson case and in the Cole case have said that when it's a crime against the person, you don't need any sort of special danger instruction. Your Honor, what
maybe it's just me, but I think he contradicted himself. It's like, oh, special danger. Then they need a special danger instruction. No, you don't need a special danger instruction. What?
I was saying was you don't even need to get there as to the question of whether there's a special danger instruction that was required or not, because here the jury necessarily found that in finding the second-degree manslaughter.
Whoa, 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 whoa. They necessarily found that? What?
Manslaughter conviction of Chauvin. And so there's case after case that says that when there's an assault, that is a predicate felony for the felony murder doctrine. And my opponent's argument on the other side is to say, well, that'll be a strict liability offense for police officers. That is absolutely wrong. Unreasonable use of force is always required. That's always the safeguard against this. And, you know, if anything, the Graham standard, which has been incorporated into Minnesota law, has been criticized as being too friendly to police officers. But here, that's what the jury was instructed on. The jury absolutely found that under that standard, Derek Chauvin acted with unreasonable force. 9 minutes and 29 seconds. On George Floyd's neck.
Any questions, Judge Larson? Judge Klopaki? Thank you, counsel. Counsel for appellant, you will have 5 minutes for rebuttal.
I want to start off the rebuttal by dealing with the second-degree murder charge. Nobody is suggesting that there's any 007 thing. The problem with using the felony murder rule under the second-degree murder statute is there's no intent. There's no intent instruction.
Well, there's an intent instruction. There's a general intent instruction because you have the assault. That's a general intent offense.
Fair enough. I'm sorry. The problem with a police officer, the intent instruction for assault, and I don't want to waste a lot of time on this, is the intent to touch. Minnesota Supreme Court has held it's not the intent to injure somebody. And the problem with a police officer when they are arresting somebody is they have to touch them. So you basically eliminate the intent.
Right, but you still have the reasonable standard, and that's under the statutes as well.
That's correct, but that's an objective standard. I mean, it's unusual to have a murder charge with no finding by or no instruction of the jury of any kind of subjective intent of the defendant. That's
fair point.
We were making.
Right, it is an objective standard, but I think what your argument, I understand your argument to be a strict liability. It creates a strict liability for police officers.
Yes.
But the Dorn case seems to undercut that argument, doesn't it?
I disagree with that analysis because of the way the felony murder statute is set up in Minnesota on assault. As we've laid out in our papers, Minnesota is a minority of jurisdictions where assault, most states do not allow felony murder where the predicate felony is an assault.
Right, and I understand that argument, but we're an error-correcting court. If that is going to change, that has to be changed by the Minnesota Supreme Court or the legislature. That's not for us to change that.
And I made that clear in my brief.
Okay.
I said that in my brief. I just don't want to get up to the Minnesota Supreme Court and say, why didn't you raise this below? You waived it.
Fair enough.
I made it clear in my brief that you're bound by that precedent.
Okay, fair enough, counsel.
I want to get back to the venue issue. I want to make a couple of points with it regarding to the presumption of prejudice. Number one, it's not subject to any kind of abuse of discretion standard. That is a de novo review. I spent quite a bit of time reading the Skilling case, and one of the things I've done in my career, which may sound a little bit odd, at times I've used statements by the dissents in cases because the dissent sometimes will more accurately or concisely convey what the majority did. So in the Skilling case, Justice Sotomayor wrote the dissent. She made very clear in the dissent that there's this presumption of prejudice standard that you have to go through first. But one of the quotes I wanted to cite from her dissent was, she stated, as I cited earlier, the Estes and Shepard cases. This is the quote from the case. Estes and Shepard thus applied Rideau's, another Supreme Court case, insight that in particularly extreme circumstances, even the most rigorous voir dire cannot suffice to dispel the reasonable likelihood of jury bias. That analysis shows that this has to be a de novo standard. In other words, the pervasiveness of the publicity, and in this particular case, combined with the physical threats in the courthouse, provide an environment that the Supreme Court has held you can't trust the voir dire at that point.
Why does it have to be a de novo standard? Why can't it still be an abuse of discretion of whether the district court abused its discretion by continuing to hold the trial in that venue, or not allowing a continuance, or not sequestering the jury? It seems like those are all under the abuse of discretion standard, aren't they?
Typically, abuse of discretion applies when a trial judge is evaluating some kind of testimony and weighing.
Well, it's more than that. It's also for evidentiary hearings, issues, I'm sorry, as well as basically trial management.
Correct. I understand that.
My motion to transfer venue, and sorry.
I'm sorry, we were both talking.
Yeah.
Go ahead.
Yeah.
Go ahead.
And a motion to transfer venue, that's up to the discretion of the district court as to whether or not to grant that motion.
Not under the first tier that I laid out. I'm getting really short on time. One factor I want.
That's okay. And just to let you know, if you need a little bit more time to answer this question, that's fine.
Thank you. I'm sorry, do I have a question pending?
Yeah, here's my I see where you're coming from, but I think isn't the overarching standard of review abuse of discretion, but a district court can abuse its discretion if it applies the law erroneously. So I see your argument in terms of whether or not the district court appropriately applied the law, but isn't that under the abuse of discretion standard?
No, it's de novo. And the reason I laid out the quote from the Skilling case was the trial court's judge's analysis of voir dire is subject to abuse of discretion because the judge is watching the jurors and the like. As Justice Sotomayor laid out in the dissent, coming from the majority opinion, the Trudeau case, there are some cases that are so extreme that even rigorous voir dire is not going to overcome a juror's bias. That to me reflects the fact that it has to be a de novo standard because the jury voir dire doesn't matter. Before I end, the one last thing I wanted to say, and I wanted to say this at the beginning, the other problem with this case that makes it very unique is Mr. Keitel laid out that no matter where this case got moved, it wouldn't matter because people would know about it and the like. The difference here is the jurors that sat on this jury had a stake in the outcome of the case because they lived here where the riots occurred. If this case gets moved out state, the likelihood of having riots in the community where the jurors are living, I believe, will be zero. Thank you.
Judge Larson, Judge Klopek, any other questions? We ran a little bit over, but I want to make sure that you had the opportunity to answer the question fully. So thank you very much.
Thank you, Your Honor.
Counsel for both parties, thank you very much for the briefing. It was very extensive, very.
That's all that. Interesting stuff. Let's go back. Let me get the Murdaugh thing on screen.
Objection to this juror being excused.
No objection, Mr. Murdaugh. None from the state.
Oh, thank you, ma'am. You are excused.
It's a little wider, so I'll take more of the screen.
The next exemption involves those of you who may be attending school or working in some capacity at a school. You have a school-related conflict and would like to be transferred to a time you do not have a school-related conflict, whether a student, teacher, other school employee. If you have a school-related conflict based on your employment and would like to be transferred, so please stand. It's in the back. Yes, ma'am. Yes. 54, high school student? All right, and when will you be available to come back?
Well, the semester just started, so I don't have time, and I don't have a vehicle either.
So the school is out May, June, July, August?
I think July.
All right, we'll mark you to come back during the summer months. Thank you, you may go. All right, we'll mark you to come back during the summer months. Thank you, you may go. Yes, ma'am.
Sorry.
4, I believe it was, or this juror number and the source of the information.
148, and then what the next was to say, like, Facebook or whatever.
All right, thank you.
203 and Crime Watch, YouTube, podcast, stuff like that.
All right, thank you.
43, internet. 45, local news. 185, local news.
That's the button I wanted.
39, news, Facebook, group, and TV special.
Number 75, Channel 5 Charleston.
So with respect to the Chauvin appeal, I thought it was pretty interesting on the law. Like, I still think the fact that they can charge felony murder is bizarro world, because Missouri is way out of touch, unfortunately, or Minnesota's way out of touch on this, but unfortunately the law is clear, and they're not going to get overturned by the Supreme Court on that, because the Supreme Court's like, this is a legislature problem, they're not going to get overturned. But
11. All right, thank you.
the juror questionnaire issue is a loser. The Schwartz issue is a loser.
Thank you.
The venue issue is probably the best issue. The venue issue is probably the best issue. And say the court either de novo review, which seems wrong, but he had some sort of legal arguments on some law, which, you know, he did the deep dive and legal analysis. But it sounds like he's stretching for de novo review. But even if abuse of discretion review, then, and also the cumulative, I think, is kind of a loser. Even if it can be done, I don't think it can be done in this case, but the venue is the best issue. I doubt very much that they're going to win. Although it's possible, I suppose, because of the federal thing, it's like no harm, no foul in reversing, because they're not setting them free. But that's what I think.
Internet, social media. I've got people that live in other countries that I've talked to. I've seen articles in other countries that have covered this case, and family, because the young lady that his son was
South Carolina seal looks good today, I have to say.
And your juror number again, please.
number 44.
Thank you.
214, local news. 149, podcast, YouTube, and 16 is a family.
You'd have to transfer it to a different jurisdiction within the state. You have to transfer it to somewhere else within the state. Different county.
26, national news.
176, news documentary, it's on Facebook.
77, news and homework.
180, Facebook, podcast, and news.
193, internet and word of mouth.
112, word of mouth, and internet.
24, internet.
166, local news, media, France. 82, internet, social media, local news. 202, internet,
Are you mocking the palmetto tree and the state flag? That's mean.
58, local news, news break, and associates. 97, Facebook, and all of those.
179, social media, news, documentary.
Animus oprisci pariti. Paired in mind and resources. While I breathe, I hope. Dum spiro sparrow. While I breathe, I hope. Okay. So they're prepared in mind and resources, and while I breathe, I hope.
Based on what you have
Okie doke.
heard or been exposed to concerning this case, have you formed an opinion as to the guilt or the innocence of Mr. Murdaugh? If you have formed an opinion in your mind as to the guilt or the innocence of the defendant, please stand.
I don't have an opinion.
And tell me your juror numbers.
44.
Thank you to the 900 of you who are currently here, by the way. If you'd be so kind as to first check to make sure that you're subscribed. It's always helpful to recheck that. Make sure to hit the subscribe. And if you are subscribed, or either way, really, hit the like button. I would appreciate it.
The innocence of the defendant, would you be able to set aside that opinion and decide this case solely and only based on the evidence presented in this courtroom and the law, as I will instruct you?
Thank you, JoJo, for the 20 gift memberships.
If you cannot decide the case based on what is presented in the courtroom and the law as I give it to you, but you will decide the case based on opinions that you've already formed, please stand. If you have the opinion you formed is so fixed that you cannot decide the case based on what's presented in the courtroom. If that's your case, situation, please stand. All right, tell me your juror number. 52. Juror number 52. And juror 52, you'll be excused. Thank you very much for coming. 30. All right, juror number 30, you'll be excused. Thank you for coming. 44. Did they say 44? All right. Thank you, Mr. 44. You are excused. Thank you for coming.
Case is crazy down here in the low country. I believe it, Jeff.
In any media coverage regarding the defendant or his family, if you've been asked to participate in any media coverage concerning this case.
Yes, Cindy Luhu, we will be covering the whole thing. That is the plan.
So please stand.
Thank you for your super chat. The only reason we weren't covering it earlier is because, well, we thought there would be no audio. And I was trying to find something else to do. And then during the Derek Chauvin thing, it's like, oh, the audio's back. And I'm like, ugh. Now what do I do, right? So I decided to finish that off and then come back. The court tricked me.
To friends, family, co-workers, or anyone about this case, please stand if you've expressed your opinions concerning this case to anyone. If so, please stand. And tell me your numbers. 220. 149.
So yeah, so the court tricked me into not covering part of it because, well, I thought there wouldn't be any audio, and there wasn't any audio, and someone said, oh, there's audio, and then there wasn't, and like, you know, it's like, so I'll go cover this other thing, and I was like, oh, the court's on. I was like, lol.
If you're any member of your family or any significant others of yours, if they are related or you are related by blood or marriage, to Maggie Murdaugh, Paul Murdaugh, or defendant Richard Alexander Murdaugh. Any of you or any significant other of yours is socially acquainted, related by blood or marriage.
And we did two Supreme Court decisions.
Murdaugh, Paul Murdaugh, and Richard Alex Murdaugh.
Oh, hey, it wasn't all bad.
And your juror number, please. 128. And who are you related to or socially acquainted with?
My brother-in-law is of the Gomez family, which is very well connected with my family.
Where'd you get that?
I believe the number was 129.
129. All right, thank you, ma'am. And someone on this side, yes, ma'am.
180. My grandmother's side of the family are related down the line to A.R. Murdaugh's, down the line from his set of Murdaughs. And my best friend of 11 years used to work.
Is it AM in the room right now? Yeah, it's 11:30 in the East Coast. 11:30 in the morning on the East Coast.
All right. Thank you. And ladies and gentlemen, backing up a little bit, the defendant is represented by counsel and the state is represented by counsel. We'll have the counsel introduce themselves first. Each state.
Good morning, everybody. My name is Greg Waters. I'm from the Attorney General's office. And,
Hi, everyone. My name is Blackleaf, and I'll be the prosecutor in this case. Alex Murdaugh murdered his wife and son. Well, golly gee, that wasn't very nice of him, now was it? As the evidence will show, Alex Murdaugh did this for the purpose of covering up financial crimes that were related to cheating his clients. Well, golly gee whiz, he probably shouldn't have done that either.
All right, ladies and gentlemen, if any of you are related...
Blackleaf's been accused of murder before, but that wasn't fair. The crowd was trying to bust into the tavern, and all I did was breathe poison on them with my poison breath.
Richard Alex
Thank you for covering this. Will you do the whole thing?
Mr. Griffin,
Yeah,
Ms.
let's do the
Fox,
whole thing.
Mr. Barber, or by the state, state's attorneys, Mr. Waters, Mr. Zelenka, Mr. Fernandez, Mr. James.
I know nothing about this trial and I love to watch courtroom.
Mr.
And
Meadows,
honestly, I prefer your coverage to even the Queen
Conrad,
Emily because I love your dry
Ms.
wit heart.
Dowd.
Thank you. That's very, very kind of you. I appreciate
So
that.
please stand, or if you're acquainted
It's
with
very
any
nice of you.
them
Thank
or
you.
have had any representation relationship with any of them.
Does it count if Mr. Murdaugh was my employer's legal representative?
Yes. Tell me your number and why are you standing?
Because my employer, Esco Gas, Mr. Murdaugh has represented them in the past.
All right. Thank you. As it relates to the defendant, Mr. Murdaugh, if you know him, have been represented by him, or have close acquaintances who...
To those of you who are watching on either Twitch or Facebook,
Yes, sir.
if you give me a little comment in the chat, hopefully I'll see it and I will acknowledge you because, of course, YouTube is where we're principally at, but we are streaming on Facebook and
Your number
Twitch.
is
as well. So let's give a shout out to the people who are watching there.
Do you believe that would affect your ability to be a fair and impartial juror? Do you believe that relationship would affect your ability to be a fair and impartial juror?
TYL Fumin is on Twitch. Thank you for watching from Twitch. We appreciate you being here.
Do you believe that you would have some bias?
Snark Daddy, Best Daddy, how's the flattery going? Hot stuff? Going pretty well, Shirori.
Any objection to this juror being excused? Thank you, sir. You are excused.
Mosaic Task Force is on Twitch. The Chandlerin is on Twitch. Chandler and DG watching from Twitch. Mosaic Task Force watching from Twitch.
I missed the last part. Represented your family and some legal issues. And would that affect your ability to be a fair and impartial juror? It might. Is that relationship ongoing or not?
Well, yeah, that reason a lot.
And during the course of that representation, were you involved with Mr. Murdaugh, Alex Murdaugh? All right, sir, we'll get back to you. Your juror number again is 124. Thank you.
I second the previous super chat smiley face.
Thank you, Becky. Appreciate it. Appreciate the love.
If any of you or any member of your immediate family or significant other employed with or has ever been employed with the Colleton County Sheriff's Office, the South Carolina Law Enforcement Division, known as SLED,
the
Solicitor's Office of the 14th Circuit, or the Attorney General's Office of the State of South Carolina. If so, please stand. Yes, ma'am. Say it louder for me.
149, my fiance was second on the scene.
Your fiance was on the scene.
This is correct. I believe he was one of the responding officers to the scene.
Any objection to this juror being excused?
My fiance was one of the responding officers.
Thank you, ma'am. You'll be excused.
Could be a problem.
Yes, ma'am.
SLED, they mean business. SLED thinks they mean business.
And ma'am, with that, your juror
What's
number
SLED?
is.
It's the state police. South Carolina Law Enforcement
Would that affect your
Division.
ability to be a fair
SLED is the state
impartial juror?
police, and they like to think that they're the FBI,
Thank you.
and they're really not. And they have a tendency of flexing their power and might and thinking that
Any
they're
of
being
you or any
self-important.
member of your immediate family has ever been arrested by, investigated by, prosecuted by
SLED is special.
the Colleton County Sheriff's Department, SLED, 14th Circuit Solicitor's Office, or Attorney General's Office.
Yeah, SLED acts like this is
So
about
please
right.
stand if any
SLED
of
acts like
you
the
or any
FBI
of
and
your
DEA and
family
ATF all rolled
members
up into
have been
one.
Investigated by, arrested by, charged by.
Yeah,
or
that's pretty
prosecuted
accurate.
By the Colleton County Sheriff's Department, South Carolina Law Enforcement Division, Solicitor's Office of this circuit, or the Attorney General's Office. If so, please stand. And ma'am, is that an ongoing matter or a closed matter? And yeah, and would that fact affect your ability to be fair and impartial as a juror? Yes. And based on that experience, you would be biased as a juror?
Yes,
And your juror number is 166. Any objection to this?
Anyone here biased by their interaction with SLED? Everyone raises their hand in the
Ma'am,
room.
you're excused. Yes,
I've
ma'am.
not had interactions with SLED personally, but I've heard tell. I've heard enough tell from my time in living in South Carolina. Again, I lived in South Carolina for 20 years.
And by
And
which
so
agency?
I've heard tell.
And would that fact affect your ability to be a fair and impartial juror?
All right, have fun, Karen. Good luck with your client.
Yes, sir, in the back.
Tell your client to shut their mouth.
You were? You are. And by which agency? Yeah. And would that fact affect your ability to be fair and impartial? I don't think so, Judge. All right. Thank you, sir. Yes, ma'am.
Jury number 95, my son is not recently and I want to pay.
All right. Thank you. If any of you or any immediate family member or a significant other has ever been employed by or represented by the firm of Peters, Murdaugh, Parker, Ells, Roth, and Dietrich, or the Parker Law Group, or if you've ever attended any functions or events, parties, hunts, raffles, gatherings, or anything of a similar nature hosted by the firm of Peters, Murdaugh, Parker, and Ells, Roth, and
Clemson kitty go meow. Meow.
or by Mr. Alex Murdaugh or his family.
So I think I'll be coming to South Carolina to attend the trial in person. No, I don't really see the advantage of coming in person, to be quite honest. But if I'm in the courtroom, I can't stream it, right? And what's the advantage of me like being in town,
Been sued
right? So
by
I don't know that I see the advantage of coming down there in
events,
person,
Parties, hunts, giveaways, raffles, gatherings.
to be honest.
Any similar events hosted by the firms, or Mr. Murdaugh, or any of their respective families. If so, please stand. Yes, sir. Yes, sir. And your juror number? 203. And do you believe that would affect your ability to be fair and impartial? I do. And you'll be biased as a juror because of that? Yeah. All right. Any objections to 203 being excused?
Based on the juror's responses, no objection.
All right. Thank you. Number 203, you're excused.
You and I can go out for
Stand back.
barbecue dinner. That's true.
And would that fact affect your ability to be a fair and impartial juror? All right. Thank you. $129? $129. Yes, sir.
Okay, now they're doing an approach to the bench, apparently. We see the judge pop into frame briefly. Accents remind you of Inherent the Win? Oh, yeah, for sure. Where in South Carolina did I live? I grew up in Columbia. And then I went to school at Clemson. No one wants to do it. Jury service. I mean, yeah, this is Sumter here. Cool. Judge looks lively. Yeah. Is there a point where the judge says we need a different venue? All the jurors are going to be biased. Yeah, there definitely is a point where that happens, and whether or not that's happened here is certainly an issue. But that's one of the reasons they apparently have 900 jurors vordeered or something. So. Gamecocks all the way? Lol, no. How's the trial long expected to go? Columbia is the capital of South Carolina, yes. I believe they said February 10th is how long they expect the trial to go. We'll be covering it all the way. Maybe I will maybe I'll come down there. Daughters at Clemson wants to go to law school. Hey, worked for me. If your daughter is looking for a young, attractive lawyer, just saying, available. So Sandra says, not sure what happened to your membership, but I renewed. Yeah, well, it's a thing. I just thought of a really bad pickup line, and I don't think I'm going to say it because I get in trouble. Say it. No, that's okay. I'm good. Lord. Young, attractive lawyer, but you're only like two of those things? Hey, 2 out of 3 ain't bad. If she's at Clemson, she's probably an adult, so it's legal, right? So that's all we need to know. You're much like Meatloaf. You'll do anything for love, just not that. Yeah, something like that.
So, based on having asked these questions, and we have this, I don't think.
Do anything for love. Won't do that. Won't do that. I'll do anything for love, but I won't do that.
I remember one trial they had to move to an auditorium-like venue to hold all the potential jurors. There was over 1,000.
That definitely can be a thing that happens, yeah. What is the upstate of South Carolina? Traditionally Greenville area. That's what people mean by upstate. Low country is Charleston. Sue says, I was sort of wondering if there was an uncivil partner in your firm.
Or otherwise, that would prevent you from sitting on a jury
I'm
and
single.
deciding this case based on the evidence and the law. If you're prevented by any religious beliefs.
South Carolina is a beautiful state, I agree.
So please stand.
Personally, I like the way the Pluff mud smells.
If you know
I
any
like
reason
that.
why
I like
you
that low
cannot
country.
serve as a fair and impartial juror in this case and give both the state and the defendant a fair trial, or any reason whatsoever why you should not be required or chosen to be seated on the jury, if so, please stand. No one standing. Ladies and gentlemen, there are many witnesses or prospective witnesses, people who might testify. And I'm going to read this list. Excuse me. If any of these prospective
Low country
witnesses
food is
are
very
there,
yum. I agree.
I'd like you to stand so the jury can see you. At the end, I need to know whether or not you are acquainted with any of these prospective witnesses.
Judge's accent isn't that bad.
Daniel Green from the Colleton County Sheriff's Office, Chad McDowell from the Colleton County Sheriff's Office, William Cody Pruitt, formerly of the Sheriff's Office, Tanisha Bryson Smith.
How do I feel about grits? I'm pro grits.
Angela
Shrimp and grits.
Stallings from the Colleton County Dispatch. Is that dispatcher? Dispatchers and being a
Mustard or
dispatcher.
vinegar? Mustard for sure.
Dathan Varnado from the Sheriff's Office. Charlie Jones, CCRF, is that Fire?
Mustard
Rescue?
barbecue.
Colleton County Fire and Rescue, Barry McCoy. Colleton County Fire and Rescue.
Virginia,
Linda
vinegar, that's some
Worley,
North Carolina stuff.
SLED. Laura Rutland from the Sheriff's Office.
Grits is girls raised in the South, it's that too.
Following people who work at SLED: Thomas Darnell, Rachel Wynn, Paul Greer, Madison Willis, Julia Begeman, Olivia
Carolina
Carter,
girls,
Rachel
best in the
Bell
world.
Johnson,
No, not grits, have mustard or vinegar. Barbecue.
Dadabo, Jeff Croft, Katie McAllister, then not SLED employed, Norris Lafitte, Claude C.B. Rowe, Roger Dale Davis, Michelle Shelley Smith,
Duke's mayo, there's no substitute. I respect that.
Maylin Haynes, Barbara Mixon, also from SLED, Kristen.
Thank you, Sue.
Moore,
I hope so. I hope I'll find someone to make. I hope I will make someone
Sarah
happy
Zapata,
someday.
Kikila Kiki Wallace, Megan Fletcher, Britt Dove,
Blue plate.
Becca Gregg, Bobby Bancroft, Brian Hudak, Tom Schenk, which one? Then Jonathan Van Housen of the U.S. Secret Service.
Memphis barbecue is best barbecue?
U.S. Secret Service.
Oh my
Paul
God, no. No,
Manifold
no,
from the
no.
Charleston County Sheriff's
No.
Office. Dylan Hightower from the 14th Circuit Solicitor's Office. Tom Bevel, John Bedingfield. Nathan
We get a shout out for Master Sergeant Robert Weber,
Wills
who left
Chapman,
us December 2022, a member of South Carolina
Chris Wilson,
National Guard.
Attorney Lee
Yes, you
Coates,
can.
Attorney
Robert,
Mike
thank you for your
Inslee,
service. Shout out, respect.
Michael Gunn, Attorney Johnny Parker, Attorney
Kansas City? No.
Carson Burney,
I am quite partial to South Carolina. I'm quite partial to pork
South
over brisket.
Carolina Attorney General.
I know I live in Texas now, and I'm supposed to be team brisket all the way, but
Carrie Sauls, Eric
I'm partial to
Hogan,
pork.
Ryan Kelly from SLED. From
Sue
EMS
Kendall
of
gives
Hampton
20
County,
euros to say to love. Well,
Charles
thank you. That's very kind of you. I
Long,
appreciate it.
Formerly of the Hampton County EMS. Curtis Eddie Smith, Attorney Mark Ball.
If you're an attractive young single lady
Attorney Danny Henderson.
and would like to date uncivil law,
Matt Wright from SLED. Savannah Memorial Hospital Records Custodian Jessica Denovan, registered nurse at Savannah Hospital. Tommy Robertson from SLED. Kenneth Martin.
To love smiling face with hearts, winking face, smiling face with hearts.
DG.
Bevel Gardner Associates.
Devil Gardner and Associates, out of state. Sidney Freeman, Hunter Wilson, Bailey Wilson.
Yeah.
Carrollton County Sheriff's Office, Anthony Russell. From SLED, Joshua.
Pork with some mustard.
Lynn Black.
Apple cider vinegar, I respect that.
Blanca Turviet Simpson, Kenny Hughes, Rogan Gibson, Will Loving,
Texas girls.
Bart Proctor,
Never dated a Texas
Randy
girl. Maybe I'll
Murdaugh.
get a chance someday.
Jenny Seckinger, Annette Griswold, Peter Radowski of SLED, Alfred Johnson from JLA Investigations, David Grubbs from the Attorney General's Office, Demi Garvin, Forensic Science Network, Kenny Kinsey, Orangeburg County Sheriff's Department, from SLED, Dave Owens, Charles Gent, Ryan McNeil, Attorney General's Office, Oswald.
Kurt missed an opportunity with a female judge in the appeal footage. He should have said, I'd like to approach her bench.
Charleston County Sheriff's Office, Greg Cook, from SLED, Courtney Adams, Jamar.
We're in jury
Tony
selection.
Alvey, Mitchell Altman, Stephen Bechtold, Alice Hazel, a CPA, Mark Altman, ITPSB, Attorney Eric Bland, from SLED, Matt Brown, Frank Chapman.
Her bed the
Charles
lizard thicket?
Chapman,
I have.
SLED, Delilah Sorencion, and Timothy Collier.
Duke's Barbecue and Grill
Highway Patrol, John Connolly.
is one of my best memories.
Barnville
The
Fire
Beacon is
Department,
pretty
Tyrone
solid.
Corbin, Colleton County Sheriff's Office.
If the Beacon restaurant's in your town, that is dangerous,
Terry
JoJo.
Davis,
That is
Terry
dangerous.
Dempsey, Richard Dixon,
Beacon's in your town? Holy
Rowdy,
shit.
Nancy Drawdy,
Beacon is the most greased
County
up
Sheriff's Office, Richard
burger
Bailey,
fast food joint in
County
the history of
Deputy
time.
David Drawdy, Donna Eason, Ashland Gant, from SLED, Hallie Godley.
Like to appeal to her.
From SLED, Jamie Hall. Scott
I take you on, I wouldn't hurt you. You just bruise a bit, you'll be fine.
Colleton County Sheriff's
Okay.
Office. From SLED, Laura Hash.
Sounds workable.
David Haynes.
Ever been to Philly? Yes, I was born in Philly.
From SLED, Adrian.
Grew up in South Carolina, I was born in Philly. So I've definitely had authentic Philly cheesesteaks, and my parents, my mom made me many authentic Philly cheesesteaks, and yeah.
Clarendon County, Colleton County Sheriff's Office, Guri, Buddy Hill, from SLED, Tommy Hines, Jonathan Holbrook, Chandler Horney,
Gator Nuggets?
Graham Holes, Stephen Hudson, from SLED, Jennifer Huntington,
Varsity is not any better. Varsity sucks.
William Hutto,
Varsity is massively
Highway Patrol,
overrated.
Jasiah James, Christy Gerald, from SLED, Hannah Jefferson,
What was my favorite cheesesteak? My mom makes my favorite
Brian
cheesesteak.
Jones, from SLED, Pat Keegan, Wayne Kirby III, Tommy Kynard, Tanya King, Richard Neese Jr., from the FBI, Mark Labrici, Henry Lafitte, Rebecca Lafitte, Attorney Rebecca Lafitte, Paul LaRosa from SLED, Stacy Lodeholt from the Sheriff's Office, David Long, Sheriff's Office, Elizabeth Lafitte Malinowski, Vera.
My daughter's really beautiful, but her boyfriend is average.
Linda McElhaney.
Well, I'm just saying, JC,
McElveen.
if she wants to upgrade,
McGinnis from SLED, Jacqueline McKay.
solve the debate. Pats or genies?
Haley Moody from SLED, John Nelson, Haley Nelson,
Between the
Peters,
two, I think I go
William
Pats.
Pope from the Sheriff's Office, Captain Samuel Wrigley from SLED, Kashyap Patel, Emily Reinhardt from SLED, Dr. Ellen Reiner, MUSC pathologist, George Riaux, RIUX, from the Sheriff's Office, Major Tommy Robertson.
We're talking about cheesesteaks.
Diane Rowe, Walter Salisbury.
Saying the varsity's overrated is
Anthony
blasphemy.
Sampson from SLED.
Be that as it may.
Christopher Serene, Fire and Rescue, Michael Tony Satterfield, Jeremy Smith of SLED.
He's reading a list of names of witnesses.
James Talon III.
Or possible witnesses.
Temple of SLED, Courtney Thompson, from DX Chelsea Townsend, Philip Turner from SLED, Dr. Luis Vega, Russell Ronaldo.
Ever been to the UK? Yes, I have been to the UK. DDS. I've been to London twice.
Western Dolph.
One of my favorite memories was in London. I got lost in London and had lunch in Piccadilly Circus. And one of my favorite memories, I've talked about it before on channel.
Fire and Rescue, Matthew Williams.
Boots and Sonnies. That name doesn't sound familiar.
Following Dr. William J. Bromberg, Caitlin Bowen, Dr. Kerry Jeter, Alice Dion, Dr. Brandon Runyon.
You left out the part where I said she prefers personality for looks. I didn't mean to leave out the part. I just said if she wants a even better, richer personality. Plus looks to boot. So, a little bit of all those things.
SLED continued, Haley Fiorucci, Jennifer Hunton, Lonnie Nettles from Sheriff's Office, David Weaver from SLED, Al Jarvis.
Rocks, Blues, and Barbecue. Cool name.
Also, Christopher Anderson, Arthur Badger, Johnny Bush, James Randall Drawdy.
Are people involved in law and court viewed by attorneys with skepticism? It's a typical rule.
Elise
Anyone who knows too much, right, is typically viewed skeptically.
Thomas Moore, Pamela Pinckney, Natasha Thomas, Buster Murdaugh, John Martin.
So I'm losing weight.
Liz Murdaugh.
I'm losing weight. People see it. They see it in my face.
Terry Brandstetter, Marion Brandstetter.
Getting healthier. I'm posting my exercises. I saw some guy.
John Dingle, Scott O'Quinn, Charles Lafitte.
I saw some guy on my recent tweet where I posted my workouts like, this is not the content I subscribe for. I'm unsubscribing. I'm like, what the hell is this?
Attorney Ann Bauer.
Post my workouts. This isn't the content I subscribe for. Grrr. Like, what the fuck is your problem?
Essenstat, crime scene analysis, Tim Palmbach, crime scene.
My commentary's gotten better. That too. That's also because I'm happier. Because I'm not as depressed all the time.
Crime scene reconstruction, Jim Persinger, computer forensics, Chick Johnson, computer and phones forensics, William Tobin, GSR firearms and ballistics, Michael Sturgis.
I sound happier. I am a lot happier since this became my full time.
Amy Brodeur, BPA, CSI, Lynn Murdaugh.
I am not married and I have no children. I've never been married. I have no children. I am looking. I am looking for a woman who would like to be married and have children.
Robinson, Kayla Robinson.
And doesn't currently have children.
Yes, sir.
Because I've found out from trying to date women that have children, it's basically not possible, at least in my experience. Because their children is their first priority, which is perfectly reasonable. But it doesn't leave enough space for me, which is annoying. Or not, at least not compatible. So it's like, so I yeah. Single, no children, never married would be preferable, but I know that's going to be difficult. Well, if I had my ideal, Could they provide the jurors with a list to read and check off? I think they did, but the judge asked, I think what happened is the judge asked, does anyone know any of the witnesses? And no one raised their hand. And the judge is like, really? Because there's a lot of them. So I'm going to read their names. I think that's where we're at in this proceeding at this point.
Falkofske from the FBI. As it relates to any of those people,
So I'm saying I'm a needy man.
you are a friend, relative,
I feel
associate,
particularly needy.
acquaintance
I need a woman,
of any of them,
or at least like a
please stand.
woman. Women are nice. They're soft, and they give good cuddles.
All right, and you tell me the basis for your standing. First with the gentleman, the juror number and why you stand.
43, Charles Long.
Say it again.
43, Charles Long, my cousin.
Your cousin. And should your cousin testify, would that affect your ability to be fair and impartial? Yes, might. All right, we'll talk with you a little further in a minute. Yes, sir.
Or a dancing woman will flock to you to take some dancing classes.
And should they testify, will that affect your ability to be fair and impartial? All right, thank you. Yes.
Sexual acquaintance with Chad Westendorf. I think you said Jerry Cole from the Sheriff's Department. He's a friend. And my son is, or was a friend with Gus Murdaugh.
And will that affect your ability to be fair and impartial? All right, thank you. Yes, ma'am.
Feel the same. Never been married, no kids. I find it very hard to find a mate at 38 years old. It's a very similar stage of life. Yeah.
A little louder, please.
Line dancing is fun.
And should he testify?
I was going to ask her to repeat the number if I could, John.
Your number again is 110. And
Learn to
should,
shag.
Dr. Vega testify,
I didn't know how to
that affect your
shag
ability
once,
to be
and
fair and impartial?
I took some shagging classes.
Yes, sir.
Cameron.
59.
Been a while, but you know.
Angela Stallings, Doris Lafitte, Buddy Hill. I know Barry Shore pretty well. I volunteered for a long time with the fire department. Now I also work there part-time as a firefighter.
And will that affect your ability to be fair and impartial? Thank you. Yes, ma'am.
55. I went to school with William Downey, and my very close friend with Mary.
Close friends with him.
Yeah, I wouldn't worry too much, spiritual hearer, about Branca. Branca has some very aggressive opinions, so I wouldn't worry about too much.
All right, we'll speak with you further. Yes, ma'am.
16, Charles.
With shagging, it's a style of dance. Shag is a style of dance.
Thank you. Yes,
At least in
sir.
South Carolina. It's the official state dance of South Carolina. You're more than a number in my little red book. You're more than a one-night stand.
Yes, sir.
Du, 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 du.
Would not affect your ability
In the
to be fair and
UK,
impartial.
I know.
All right, thank you.
Number 58, there's two officers that are customers at my place in employment, and so I have my position.
All right, thank you.
Number 152, some that you said the name Jordan James. If you did, that's his sister married to my son's maternal grandfather.
Well, in the UK, knocking someone up is something very different too.
Thank you.
So, shagging is different in the UK, and knocking someone up in the UK is very different. UK is a strange place. Strange things. By the way, for those of you who are not aware,
Ladies and
in the
gentlemen,
UK,
having
to
gone through
knock
this
someone
full
up just
battery
means to
of
wake them up.
questions, if
In the US, it means something
point in time
different.
and reflecting on all of the questions I've asked you, if you know of any reason why you cannot serve as a fair and impartial juror, please stand. Any additional question proposed by the state or the defense?
Let's not discuss Fanny in the UK. Lol.
All right, thank you. So this panel is now qualified. And the question then is, what next for this group? Yes.
To knock someone up doesn't mean wake someone up in the UK. It used to, at least. He knocked me up. He woke me up. Maybe its meaning has changed. But it generally means pregnant? Okay, well, maybe I'm out of touch things. Maybe I'm out of touch. No, it's not me. It's the children who are wrong. Yeah. I do declare. Yeah, we could have a I do not declare thing. That'd be funny. What happened to the son's case? Well, the son's case is non-existent because the son's dead. So, yeah. You can't cope with the word fanny? Apparently not. I saw that one show where they're like endlessly laughing on the term fanny because the person's name is Fanny and they're just laughing like crazy. It's like, dude, get over it. But apparently not. Apparently it's like the funniest thing they've ever heard in their lives. Okay. Like we may be 12 years old over here, you know? All right, consider looking out the US for waifu material. Yes, I'm open to that possibility for sure. Not sure how exactly I would go about that, but yes, I'm definitely open to the possibility. What happened to our Outback adventures? Hey, we can do Outback too. You know, hey, crikey. You know, I'm all about that. Become an adjunct professor and you'll have your pick of the litter.
Come forward. Jury 55 to come forward. Any other jurors? And number 26 to come forward. And if you all would come forward and just stay where you are for a moment there. You know, just want to identify you. All the other jurors, you're qualified. We're going to excuse you for the remainder of this day. We need you to call in.
Kids, what else? Age limit? Well, since I'd like to have children, Kizzy brings in a practical age limit.
For you to use.
As to bony or fluffy, I suppose between the two possibilities, bony. I suppose.
Lori, is that Weeze? Where is she? She just went back down. Oh, she's the one doing the calling. Sitting right there, Ms. Lori Weeds, Sherry Robinson, right here. Our court reporter is Elizabeth Harris, who takes down everything that's being said. She's over here, as well as Mike Watkins over here. If you have questions or issues, you address them to clerk staff.
The world is in crisis. We need more Kirk Jeans. That's what I'm saying.
Bailiffs designated.
Speaking my language.
Respond to questions, but do not engage in any way with any of the lawyers or any other witnesses or participants in the case. So we'll have you, we have several groups coming in, just like your group. We have 3 or 4 groups coming. And we
In a
hope at
world.
the end of that process of going through all of the groups to come up with one final group out of which we will select the jury. So we need you all to call back after 6 p.m. today, not before 6 p.m., after 6 p.m., and there will be a message on a recorded line telling you what time to call back tomorrow or what time to come back tomorrow. It's our hope that you might be able to come back around 4 p.m. tomorrow. We don't know that. That's why we need to have you.
Yeah,
call in
it'll be 12
to
plus
find out
alternates.
whether you need to come
I'm not
back
sure how many
for
alternates
tomorrow.
they'll be seating, but I would imagine
Next
some.
day. We'll have a message for you, giving you further information.
This is old black judge. I don't know if he's
Thank
that
you very much
old.
for all of your cooperation.
I mean, I've only seen him briefly,
Sorry
but he's
for
not
the
super
George
old.
mention. The rest of you are excused. Mr. Waters, before you go, yes.
Your Honor, I apologize. I believe in going through the copy we just did, also 124 was one that you mentioned that we wanted to have a quick discussion.
All right, mesmerizing baby blues. Hey,
Additionally, the state would also request,
how you doing?
that juror number 22.
My name's Kurt, also known as Uncivil Law.
So
How you
far,
doing,
I have
baby?
43, 55, 26, 221, 124. Any requested by the defense?
Thank you for the 900 watching and the 1,500 likes. That's very, very kind of you. 54 new members today also, not bad. I appreciate all the people, new members. If I'm monetized on YouTube, does California tax me?
One
No.
moment, yours.
No, California does not tax me. Thank God.
Yeah, thank you. Yes, ladies and gentlemen, once you have become a part of the jury pool, then you are to not engage in any form of personal investigation, exposure. You're not to read, discuss, seek.
That's pretty good for a first day trial. I agree.
Information
That's pretty good.
concerning this case, and you're not to discuss it with any.
What I like to do on a date?
or anyone else.
You.
And we'll give you a greater, more detailed instruction concerning that, should you be selected on the jury. Anything else requested?
No, Your Honor.
Thank you all.
This is how I get into trouble. What hobbies do I enjoy? Improv comedy. I'm looking. I'm going to start taking improv classes again. I hadn't taken classes for a while, of course, because COVID made it impossible. But improv comedy. I started doing improv comedy just before I moved out of
We
DC.
had to.
There's the judge. I don't think he's super old.
Stay with us. We want you all to.
I moved out of improv
I'm at a time,
doing
first
it.
juror number 26.
Doing improv comedy. So I'm going to start taking improv classes again.
We're gonna go back there.
But yeah, I just contacted I think it was Hideout Theater in Austin about signing up for classes, and they got some classes starting in February. I think it's Thursday evening, 7:00, if I remember correctly. And it's like I can do that because then I'll be done by here, and I can do Thursdays, and that'll be fun. So improv comedy is something I'm looking to do soon. And outside of that, YouTube takes a fair amount of time, but it also leaves me a fair amount of time. I like working out. I've been doing that. So I like working out. I like lifting weights, more specifically. Favorite comedian? Probably Mitch Hedberg is my favorite comedian. Do I play any musical instruments? Not right now. Janet says, please hush so I can hear what's going on in the courtroom. Okay. Oh, keep talking? Okay. I was wondering if someone wanted me to keep talking. Catherine Frazier, member for 3 months. Goat scream. The goat scream is an occasional thing. You do improv? That's cool. So improv, working out. I like to go to wineries, but I like to go with somebody. So if we were in a romantic relationship, we'd probably go to like wineries, breweries, distilleries, that kind of thing. I like doing that. That's always fun, going to like wineries or stuff. You go out, you have a nice little drive, spend time with your significant other in the car, and that's fun. And then you get to go to the winery and you get to enjoy the tour and get to learn a little bit about how wine or beer or whiskey is made. You get to learn a little bit about the techniques behind it. Then you get to enjoy it. And sometimes you get like a guitar player or something, and then you can just have like a glass of wine and listen to the guitar player. And sometimes it's outside, and so you can listen to the birds chirping and enjoy it and stuff like that. So that's really fun. That's something I really like to do. And then of course it's educational in and of itself, because you get to learn a lot about the wines and how wines are made. You get to learn a lot about what you like and what you don't like. And so it's a learning experience that you get to enjoy with someone. And you get to find out what kind of things you like and what kind of things you don't like. And then you go out for a nice dinner afterwards or something. You're driving back from the winery and you're like, oh, that restaurant looks cute. Let's stop in there and have dinner. And then that's a romantic adventure. So that's fun. What else? I haven't been shooting in a while, but I do like pistol shooting. It can be very calming in a lot of ways, because it requires a lot of concentration. So it can be very, very zen. I like that. What else? I like just being in each other's company. I just like being at home, and she's doing whatever and I'm doing whatever, and just that we're there, like doing our things. And I like cooking a little bit, playing the Switch at home. I like the Switch. Yeah. Those are the kind of things I like. See, great winery right outside Fredericksburg. They also have an authentic German restaurant that's very good. See, Jennifer, you're speaking my language. That sounds like a great date to me, Jennifer. That sounds like a great date. We'll go drive to the winery in Fredericksburg, enjoy the winery. Maybe we'll hit up a couple wineries. Listen to some music, listen to the birds, enjoy the weather, go to the German restaurant. You're talking my language, Jennifer. That sounds fun. That sounds fun. I've never been to a rodeo. Would improv help you with public speaking? Oh yeah. The Nimitz Museum? Sounds fun. I'm the perfect boyfriend on paper. I'm the perfect boyfriend in reality. Do I like winter? No, I oppose winter. Skiing, I've been skiing in a long time, but I did enjoy it. So we can visit the skiing and rent skis and enjoy a day of skiing and then huddle by the fire and then come back to the not skiing. That would be fine. We can do that. And maybe I'll try to learn snowboarding again or something, because that could be fun. or not. There's about to be a Jennifer Warren here. Plenty of Kurt to go around. Jennifer Stacks. Lol. You guys have corrupted me so much. You guys are real funny. Yeah. Love is sharing a well-cooked face together. I agree. I agree. Yeah, I guess, or maybe there is a fight. Maybe you guys, Jennifer, whichever Jennifer gets to me first, I suppose. Jennifer's married, but would love for Kurt to find a great lady. Well, Jennifer, if you want to help, in terms of that, I will take all the help I can get. Anything happening with Murdaugh? No. I'm assuming that they're on some sort of break. There's at least 2 gens that want to try me out. Well, contact me for further details, I suppose. How old am I? I just turned 42. Just had my birthday in January. Thank you. Maybe 2 years older than me in May. Thank you for following. I appreciate that. What are my favorite things to do? I thought we discussed that. We've been discussing like what I like to do and stuff like that. Improv comedy, wineries, shooting, YouTube. I like to do fine dining. I'm a sucker for service. I'm a sucker for quality service. I like being at home. I like, just chilling out at home. We could game together. We could play the Switch together. I like to have conversations. I like to talk. I like to think. Music. I'm pretty flexible on music. One of the things I like about Austin is that there's a lot of great music venues. We could just go out in the evenings to like any number of bars and just listen to music. But bluegrass is probably my like one favorite genre. But I'm pretty flexible in music. I can do like classical music. Chamber music is a lot of fun. Yeah. Laura, I'm sorry to hear that you're sick. I hope you get better. "38, been married, ain't looking for marriage again. I'm enjoying my time." Well, Shirori, that might be a problem for our relationship. Xbox, PlayStation, or PC gaming? PC and then Nintendo. Am I from Austin? I live in Austin. I've lived here since 2000. Yeah, February 2000. Who are my favorite bluegrass artists? Pizzale Sisters. First name that comes to mind. Do I do back rubs? I do back rubs. Yes. I also like back rubs. No, I haven't line danced. No, I'm sorry. Did I say 2000? I meant 2020. I'm sorry. Did I say 2000? I apologize. I meant 2020. I moved here February 2020, just before the pandemic, and then the world shut down. I apologize. I misspoke. You're married? Well, yeah. You being married would be a problem for our relationship. That would be a problem for our relationship, Teresa. So yeah. Am I looking for a woman who challenges me intellectually? I'm looking for a woman who can think. I give great back rubs. Should I apply? Yes. You should absolutely apply. Age minimum? Well, legal. Lol. But probably realistically, well, let's see. Half my age plus 7, so that's half my age because I'm 42 is 21, right? Right. Plus 7, 28. 28. But realistically, 25 will work. I'm willing to bend. So somewhere between 25 and 35. What's the plus 7 for? You never heard that before? Half your age plus 7? That's supposed to be like the standard rule for what your dating age range is supposed to be. How young can you go? That's the standard rule, apparently, is half your age plus 7. It's like, how young are you allowed to date is half your age plus 7. I'm not sure where that came from, but that's apparently the rule. In which case, that would be 28. So I don't know, but I'm willing to bend. So somewhere between 25 and 35. And the oldest I can go is based on pragmatic considerations. Because I'd like to have children. And so I'm just trying to look at like biological reality, like how, there's a biological reality. Now, like particular women can defy the biological norms, but, as a standard of like biological norms, if she's already 35 by the time we meet, by the time we get married and start having kids, right? You're thinking 37, 38. It's like it's going to take 2.5 years for us to date, get married, and have kids. Realistically, if not more. So Hillary Swank having twins at 50 is the exception. And I could adopt, but it's not what I'm looking for. I want biological children, and I don't think it's wrong to want that. Yeah, you had your last kid at 40. Yeah, exactly. So like if I want to have kids, right? If we meet at 30, if we meet and she's 35, by the time we're having kids, she's 37, 38. And then, if she has her last kids at 40, we're looking 1-2 kids. So it's just numbers. I could do that in a weekend plus 9 months. I could. Just like, Bailey says, I was pregnant after 6 months and married after 5 years. Okay, well, I mean, there are exceptions to the rule. I'm just trying to like look at numbers. How many kids do I want? 2 or 3, I think, probably. Your husband's 20 years older than me? Yeah, that works. So 20 years younger than me would be 22. So back to the college kids, back to the woman who has her daughter in Clemson, where like she might be, you know, she might be 20, 22. Yeah. What kind of husband am I looking to be, letting a woman stay at home? When we have kids, for sure. Yeah. Am I religious? Not especially, no. It's a major component of my life. I staying home as a partner? Yeah, probably. I'll be at home a lot. Probably. Once you have one kid, sometimes you realize there'll be more than enough. Maybe. Is this about murders or marriage? Why not both? Fun. I'm 26 and trying to pop up more children before 30 because the quality of eggs goes down significantly. Okay, curious bunny. About 2 to 3 kids would be perfect. Ended up with 5. Would someone that is real religious be a deal breaker? Not necessarily, no. How many wives do I want? 1. I'd like to be married once. Unless, of course, she dies, in which case I don't know. But I don't want to get divorced. And if she dies, I'll probably be so fucked up I won't be able to do anything else anyway. Probably crawl into a hole. Travel, I know people that met someone while traveling. Yeah. I guess the court's on break. Did anyone hear when they're supposed to like come back from break? Do I have time to eat soup or what? Do I end the stream and like come back with another stream in the afternoon? Does anyone know when the stream is supposed to come back? Anyone here? Because I missed it if they said. It might be done for the day. I doubt that. I doubt it. Let's take a look. Yeah, let's take a look at Twitter, see if we can find out what the court is doing. What soup do I have today? One I made myself. It's a beef vegetable soup. Pretty good. I think next time I'm going to make like a cowboy soup though. Kind of like an upgraded chili. Let's take a look and see what's happening. Someone messaged me saying, why is Joe Neerman suspended? What happened? What can we do about it? This is the first I'm hearing about it. I know nothing about Joe Neerman being suspended. I know that Joe Neerman was doing a live stream and had his live stream struck down. And maybe he was suspended as a result of that for a community guidelines violation? I don't know. Find a nice Ukrainian girl who can make some borscht. Are defendants allowed to attend jury selection? Of course. Absolutely. He took down his own Twitter. Yeah, I don't know anything about that. So he could focus more on YouTube. That makes sense. Legal Mindset messaged him this morning. Joe says Twitter isn't suspended, just focusing on locals. That makes sense. Okay, that makes sense. Yeah, I understand that. That makes sense. If the woman prefers to be the breadwinner, would you be the primary child caregiver after, say, the kids are 2 or 3? I don't know. I hadn't really thought about it. I guess maybe. I'm open to the discussion. I have questions. I'm open to the discussion. Let's put it that way, because I hadn't really thought about it. Where is my... I have too many windows open. That's what's... I can't... Where's my... Too many... Let's see. Take a look at this tweet. Recent followings of the Murdaugh case have included attachment some really graphic reports. Food trucks outside the courthouse. Oh my God, they've got elephant ears. Wow, that's funnel cakes, by the way, in case you're not familiar with the name. That's like fried dough. Just a fried dough with like toppings. They got fucking elephant ears outside the courthouse. Holy shit. Do we have to go far? Do we have to go full carnival on this one? Holy God. Crafty Mama said The Bachelor-in-Law, the new YouTube series. That could be. It could be. Reality show. Trials of circus could be. I'm trying to find out now what some information in terms of this Murdaugh thing. I'd like to know when they're ending and when they're coming back. What have we learned from jury selection so far? Apparently, everyone is related to everyone, is what we've learned so far at jury selection. Everyone is related to the attorneys, and everyone is related to the officers who showed up at the scene, and everyone is related to the judge. And this is just one massive family reunion. Apparently, the family tree in South Carolina is more vertical than some other places. Why does the camera keep shaking? I don't know. What do you want from me? And those are not related, are represented by the Murdaugh firm. Yeah, for sure. They are done for the day. Do you know that for sure? That they're done for the day? Because, I mean, it seems like they're early, that they'd be done for the day. The jury selection going tomorrow, it was scheduled to be. When they kill the stream, if they were done for the day, I would think. I'll ask Law and Crimes chat. Maybe they know. Probably at lunch. Yeah, probably. It'd be nice to know for sure, though. Court is frustrating me. More likely on lunch till 1. I'd like to know for sure if I'm going to schedule something. This is very entertaining dialogue right now. There's a woman and she's gone. Law and Crime doesn't seem to know, or at least they're not telling me. For the 739 of you who are currently here watching absolutely nothing, except the state seal of South Carolina in all of its glory, thank you very much for being here. Thank you very much for the 54 new members who have joined the channel, for the 1,600 likes that have been put in. If you've not already hit that like button, I would appreciate it. Help with the engagement. If you really want to help, you can go onto Twitter and retweet the link for this, which I believe is my pinned comment on my Twitter page. My Twitter is just Uncivil Law, at Uncivil Law. And if you really want to help, you can go onto Twitter and just simply retweet it. You don't even necessarily have to like write anything more. But if you just simply retweet it, it will help to bring attention to the stream, and that would be super appreciated. So there's something you can do for no cost. Simply just retweet the link to the stream. That would be great. Tina says, I'm looking great. Thank you. I'm feeling better. The workouts have been going better. This would also be, incidentally, why it'd be helpful to know when the court is coming in and not, so that I could plan things like workouts, because I plan on doing this every day. And it would be nice to know how long the court's going to be out, so I can know whether or not, for example, I have time to do a workout in the middle of the day, or whether I'm going to do it at the end of the day, or whatever. So that would be nice. What have you missed? We've been watching jury selection so far, AT. Is it a quote tweet, or are we republishing? Lol. You'll be fine. You're keeping me company while I bill your client? Okay. How did your client keep their mouth shut or not? Do you want to comment? Lawyers probably drove to 5 Points. This isn't being held in Columbia, so I doubt it. I doubt it. 5 Points is a little way away. Just got back from the park. What'd you miss? Jury selection is ongoing, and we're unsure how long the court is going to be away, because they didn't appear to bother to tell anyone. So the court is away, and we're not really sure for how long, and we're staring at the state seal of South Carolina, which is a very nice seal, to be sure. But it is not the, raking thing. And we watched Chauvin's appeal. That was interesting too. Thank you for retweeting, Am I Jax? I appreciate that. Can I translate the Latin on the seal? We did earlier. We looked it up. The Aminus Operuski Periti means basically being prepared in word and deed, so that we're prepared. And Domus Spero means while I live, I breathe. So we looked it up. Can you get a rundown? Well, sure. There is also some information in the video description, but Alex Murdaugh is a disgraced, disbarred attorney who is on trial for murdering his wife and son. Also unrelated, currently facing like 103 other charges for financial frauds, principally. Also, we've been playing matchmaker, and there's been some interest from the Jennifers, apparently. You need dinner suggestions for Austin? What are you in the mood for? If you want barbecue, then Terry Black's is my recommendation. Retweeted. Thank you, ADR1, for retweeting. I appreciate that. Tammy retweeted. Thank you for retweeting. Appreciate that. Ask Mindset about when they're coming back. Him and Vices are still streaming. Went to Georgetown yesterday. That's cool. 750 loyal ass folks. We love you, Kurt. You got to know that? I do love that. Thank you, Deb. What was Chauvin's appeal about? There were a couple things. Problems at the trial. So there was one juror who they felt kind of lied, but I don't think it's enough. It's not a clear enough lie. It's not direct enough. And so I don't think that goes anywhere. There was also discussion of the big one. What else didn't work? There are a couple other ones that didn't work. So the juror problem didn't work. The compound witnesses. Apparently, that's not something we can object to. Apparently, also, I don't think it really works. Check Live 5 News. Okay, let me check that. It's a good call. But the best argument was for the venue, because it was such a problematic place to have the trial. Excuse me. I'm not seeing anything on Live 5 News either, to be honest. There's a live blog. Live blog. See development below. Qualified jurors in Group 1 dismissed. That was 11 minutes ago, and that's all they have. Individualized questioning, potential witness list. So they just say, okay, the qualified jurors in Group 1 were dismissed, and that's all they have. So that's unhelpful. Jeff says you tried DMing me. Well, let's take a look. Jennifer says, I'm dying to know the jokes now. Did judge open by saying it's a great day in South Carolina? Probably. If that case didn't warrant a venue change, no case does? Yeah, I feel that, Scott. Judge is back? Yes, the judge is back.
Good afternoon. Ladies and gentlemen, I am Clifton Newman, and I am presiding in court here this week. You've been summoned for jury duty in the case of the State versus Richard Alexander Murdaugh. Mr. Murdaugh, if you will stand and face the jury panel.
Murdaugh. The judge says Murdaugh, so I'm saying Murdaugh.
Ladies and gentlemen, in order to serve on jury duty, you must be qualified to serve. We're running behind schedule due to the volume, number of people we're dealing with. So what we're going to do is to do the roll call, then take a break for lunch, then come back, and there are a lot of questions I need to ask you all.
So that wasn't the lunch break. That was just the break between panel 1 and panel 2.
Will be in the pool of jurors.
That could have been made clearer. But that's what they did, right? They brought in a panel of jurors, and from that panel they did the voir dire, and they've got some of them that are qualified, and now they brought in another panel of jurors, and they're going to rinse repeat. Right? So that's the way they're doing this, which makes sense. So they brought in, let's say 20, I don't know, they brought in 20 jurors, and some of them are qualified, and then they rinse repeat, qualify, and then they're going to voir dire some more.
Take lunch if you'll give the clerk your
Maybe per panel, I'm not sure. I picked 20 out of a random number.
Court here in Calvin County was Becky Hill. She's ably assisted by her deputy clerks, Ms. Sherry Robinson, Ms. Lori Weiss, and we'll proceed, Ms. Hills.
Thank you for coming, for waiting, and for being here, ready, willing to serve. I'm going to call your jury number out. Do not call out any names. And when I call your number out, if you would stand, if you have a mask on, please take it off, just for that particular time that you're going to be talking. I need for you to speak loudly, speak slowly, and if we still can't hear you, I will ask you to come up to this podium up here. So please, if you want to stay where you are, please speak loudly for me. I'm going to start with juror 228. So if you'll stand, I'll guide you with some of the questions, and the rest of you pay attention so that you will know what to say possibly without me having to guide you with that. But I do not mind guiding you. So juror 228, do you work currently? Okay, speak louder for me, please. You do work. Where do you work? Public service?
Public service.
Republic service. Did I get that correct? Okay. Are you married? No, you're single. Thank you. You may have a seat.
Madam Clerk, do we certainly have a mic portable mic to pass around?
Judge, we thought we did, but it doesn't go with this particular system. That's why I'm trying to get them to talk as loud as possible.
Okay.
Okay. But if we can't hear them, Judge, would it be okay to bring them to this banister and have them speak up?
Yeah, if necessary, we'll
Okay.
see how it goes.
Okay. Juror 240, can you please stand? Thank you. Do you currently work? You're retired. Yay, you. What did you do before you retired?
I was a travel agent.
Travel agent. Are you married?
I am.
And what does he do? What did he do before retiring? Thank you. Did everyone get that? Juror 244, please stand. Do you work currently?
Yes.
Where?
Department of Social Services. I am single.
Thank you. Appreciate that. Juror 248.
Hey, juror 244, since you're
Do you work
single,
currently? Where do you
uncivil
work?
law.
And you are single. Thank you. Juror 249.
This is a good way to get dating
Take your
dating
mask down,
states, right?
please.
This is a good way to
You
find
work?
dates, right?
And
By
where do
listening
you
to voir dires, and they answer all the questions,
That's it.
and then I like
Yes.
find them and I like write them and be like, "Hey, juror 224, I heard your voir dire.
Thank you.
I think we'd really hit it off. I
Juror
heard from your voir
251.
dire that you like going to the movies. I also like going to the movies."
Juror 249. Did I call juror 249? Is that my UPS guy?
Yes.
Okay, gotcha. 251. You'll stand, please. Thank you. Do you work currently? You do not. Have you ever worked? And where? Home health. Are you married or single? Divorced. Thank you. Juror 254. Same questions. Do you work currently?
I'm going to get a sheet of paper. I'm going to get a legal pad and start taking notes about which juror I like the most.
Okay, thank you very
And then I'll
much.
petition the court for the name.
Juror 255.
And then I will find them.
Do you work
Be like,
currently?
"Hey, I heard your voir dire, baby. Can't get enough of your love, babe." That's not creepy in any way.
He works for Beaufort County as well, and doing what? Facility maintenance. Thank you. Juror 257. Thank you. Do you work currently?
I could go to courts. I could go to courts in Austin and just watch voir dires.
Did you work before retiring? Okay. Probation agent? Okay, and if you don't mind telling me one more time what you do for a living? What you do for a living, what you do. Okay, thank you very much. Juror 258. Good afternoon now. Do you work currently?
No, ma'am.
Have you ever worked?
No, ma'am.
Okay. Are you married or single?
I'm single.
Okay, thank you very much. Juror 259, you would stand, please. Okay, you're in the back. You know what that means. Okay, do you work currently?
Yes, I'm a county here.
And
Another state structure of athletics down in
all right, thank you very much. Do we need anyone to repeat for that?
I got it, thank you.
Okay. Juror 262, you would stand, please.
Yes, ma'am. Department of Veterans Affairs, where he works for Orangeburg Sheriff Department.
All right, thank you very much. Juror 266. Do you currently work?
Why are they asking
Yes,
these
sir.
kinds of questions?
And
Conflicts
what
checked.
Okay.
Conflict
Are you
check.
married or single? Thank you very much. Juror 267. Do you work currently
I work at Larby Tailor Shop in Beaufort.
in Beaufort?
I'm self-employed.
All right, you married or single? Single?
Divorced.
Divorced, okay, thank you. Juror 278. Hi there. Or do you currently work?
Yes.
Where?
Short name, College in Ridgeville.
Okay.
Do I currently work?
She's disabled? Has she
I'm
ever
self-employed.
worked before being disabled? What did she do?
What do you do?
Okay. Thank you very much.
It's a good question. What do I do? Legal educator.
Do you currently work?
Yes, ma'am.
And where? Okay, thank you. Juror 284. Good afternoon. Do you currently work?
No, ma'am, disabled.
Did you ever work before becoming disabled? Robert or Bosch? And are you married?
Separated.
Separated? All right, thank you very much. Juror 587. So we got a juror 587. Okay. Oh, could you pull your mask down for me, please?
Work at Charleston County School, been years already on site manager. I'm married.
Yeah. George Woods, 77. What do you do? I'm a drug dealer. I deal drugs.
Thank you very much. Juror 294. That was 587. 587.
I human traffic. Traffic in the humans.
294. Thank you. Do you currently work? You're in school. Great for you. Where do you go to school? Thank you. Are you married or single? Okay, thank you. Good luck. Juror 303.
These questions standard for trial? Pretty standard, yeah.
Thank you, sir, for being here. Do you have a card with you in case we need some electrician services? I'm not kidding. You just let me get your information. All right, juror 306. Hello. Yes, sir. Oh, I didn't hear. I know you're married. Capital One. All right, thank you.
What's in your wallet?
Juror 319. Good afternoon.
I work at Bucket Creek Ventures in South Carolina.
Thank you. Juror 322. Good afternoon. Do you currently work? Okay, I'm going to have to get you to talk a little bit louder. Okay, where do you work? Okay. Are you married or single?
Did I hear about the juror in the Masterson case lying on the juror questionnaire? I did not hear about that, Rachel. That's news. Also, you have a nice profile picture.
Hi there, back in the back.
I work for Joe's Truck Accessories, and I'm currently single.
All right, thank you. Juror 327.
As a lawyer, can you get picked out as a juror? Yes,
Do
it's
you currently
possible.
work? Where?
I wouldn't expect to, but it's not like categorically excluded.
W International. Okay.
Me being on a jury would be
And are you
really
married or
interesting.
Single? Single. Thank you very
Yeah.
much.
Do you work or do you work? It's like, well, I'm self-employed. What do you do? I run a YouTube channel.
What do you do
I
with Carolina?
create content for YouTube. What kind of content?
Okay. All right. Is that
Legal
on
education,
Metro?
and commentary.
You're in Charleston? Okay, thank you. Juror 336. You'd stand, please.
Yeah.
Good afternoon.
I do a lot of
Currently
legal
work?
analysis and Supreme Court
Unemployed?
opinions, and yeah.
Okay. All
You mean you
right.
don't recognize me by face? Can I ask you to subscribe to Uncivil Law, by the way?
337.
That'd be good. Just throw that out there.
Afternoon. Do you
Can I ask you to
currently work?
subscribe to my channel, Uncivil Law?
Okay. Married or single? Married. Where does
That's some ultimate grift, man.
Okay. Thank you very much. Juror
How's the court,
338.
how's the court not subscribe to my channel?
I am a homemaker. I've always been a homemaker. I'm married. My husband owns his own business. It's woodworking.
All right, thank you very much. Juror 343. Thank you very much. Juror 346.
Good afternoon. I'm an accounting officer for First Federal of South Carolina, and I'm a single.
All right, thank you. Juror 349.
Offer the court a free trial membership?
Do we need to repeat that? Do we have that?
Yes, please, one more time. Thank you.
If I could get you to say that one more time, if you don't mind, Ms. 349.
International Faith
Okay. Gotcha, thank you. 351, please.
I'm retired. I was a special ed paraprofessional. I am married. My husband was a quality manager.
Okay, thank you very much. Juror 358.
South Carolina Department of Transportation, single.
Thank you. 363. Good
I'm
afternoon.
married here for my parents, and I'm single.
Okay, thank you very much. Juror 367. All right, thank you very much. We appreciate your truck drivers out there. Juror 370.
I'm a homemaker, married, my husband is
Thank you very much. Juror 374. Thank you very much.
The trial is being held in the Colton County Courthouse.
I am retired from the Postal Service, currently on disability from
In Walterboro,
and
for those of you who asked.
he works for NYRA.
Okay, thank you very much. Juror 384.
I'm retired.
What did you do before?
Colton County School District for 32 years, 15 years teaching U.S. history
Which is about
as an administrator, and I'm happy to report.
I missed what happened.
So number 387, I'm sorry you have to come behind that. Number 387.
South County School District, but middle school, I'm single.
What did he say?
Very much.
Happily divorced?
Juror 390.
I work for MBA Logistics. I'm an HR administrator. I am married. My husband works for Prime Logistics as an operations manager.
Thank you.
Yeah, anyways, it's about 45 minutes west of Charleston.
Beaufort County School District, Montessori teacher, and I'm single.
Thank you. Juror 394.
Self-employed, married, USPS.
Thank you. Juror 395.
I'm a stay-at-home mom. My daughter has a seizure disorder. I'm married. My husband is a foreman at Southeastern Limited.
Thank you. Juror 396.
I work at Southeastern Elementary, and my wife's a stay-at-home mom.
Keep it in the family. Thank you. Juror 397.
I'm a manager at Waffle House.
Waffle House!
I'm on disability, formerly a construction worker.
Thank you. Do you like Waffle House? Juror 398.
Do you know Kung Fu?
I'm an office assistant for a real estate company and I'm single.
Thank you. Happily single. Juror 400.
I'm a machine operator at Harris Engineering in West Columbia, and I'm divorced.
All right, thank you. Juror 403.
I'm retired. I have first retirement, law enforcement, second retirement, registered nurse. I'm married, she's retired.
Thank you. Juror 405.
I'm self-employed, I'm married, and my wife is a stay-at-home mom.
Thank you. Juror 408.
All hail Waffle House. Damn straight, man. Waffle House kicks ass.
Single or married? Single. Okay, thank you. Juror 413. Good afternoon. Work?
Self-employed.
Self-employed.
Single.
Thank you. What do you do, self-employed?
Underground utilities.
Okay, thank you. Juror 420.
I'm self-employed and married,
What do you do?
handyman work.
Best pecan waffles in the country? I represent that.
Let us know what you do. Give us some information on your way out. Juror 426.
Ridge Baptist Church,
The first place I went after having my daughter was Waffle House. Like speed dating for jurors? It's a little bit like speed dating for jurors. Voir dire is speed dating. I guess that, yeah, that's fair.
Good afternoon. And do you work? Okay. Are you married or single? You're married. Is this your lovely wife?
I want you smothered, want you covered like my Waffle House hash browns.
Okay. Well, thank you very much. Okay. Juror 436. Good afternoon. Do you work? Okay. And you're single. Thank you. Juror 438.
That was a bit creepy.
Department of Juvenile Justice, single.
Thank
It's a
you.
song.
Juror 439.
I'm a government contractor at the logistics center, and my husband's a retired electrician.
All right. Thank you. Juror 441.
I work at Verizon and I'm single.
Thank you. Juror 446.
Currently work at Dr. Susie Mills in Islandton, South Carolina, and my husband is a registered forester.
He's a registered.
Forester.
Thank you. Juror 447. Hi there.
I work at Dunkin' Donuts. I also go to school, and I'm single.
Thank you.
I'm trying to change that, but
You and me both, brother. You and me both.
Donuts, we thank you. We're here to serve. Thank you.
Wow.
That's what we do.
Is
there anybody's number that has not been called?
I'm looking. I'm trying to change
For
that.
me, please. Okay, I'm gonna
He
give it to
had
you.
mine. He stole my idea.
What's your number?
He stole my idea. He's using Vordeer as a dating service. Damn it.
427. And what do you do for a living? Disabled. Did you work before becoming disabled? Okay. Are you married? Okay. Okay.
Hey, babies. All the single ladies. I'm a single man.
432. Okay.
This is the best trial. This is the best trial
Is there
because we had the most
anybody else
fun.
before we turn it over to the judge? Thank you very much for
More
coming
dates?
today. Judge Newman, they're all yours.
All right, ladies and gentlemen, we're going to break for lunch and have you come back at 2:30. The juror who is here, number 430, I believe.
Yeah.
And are you disabled? So you will
I have
not.
to create a thumbnail for this
You do
afternoon.
not need to come back, juror number 430, disabled, and the juror in the back. What is your disability, sir?
He's had a kidney transplant.
And you're disabled and can't serve on jury duty?
Need to create a thumbnail for this afternoon.
Can people who are related to each other,
So we're
but
gonna
not the
excuse you
parties
as
or
well. The two
witnesses,
of you
be
will
on
not
a
have
jury
to come
together?
back.
Yes,
What
it's
if they
possible.
just know each other?
It's possible. No one objects.
Any other disabled jurors? Yes, sir.
Currently on disability with stenosis from my back, but the more significant issue is that I have narcolepsy.
Your juror number is?
383.
All right, number 383, you will not have to come back. Yes, sir.
I'm on disability, but I'm also the primary caregiver for my 85-year-old mother who is in a wheelchair.
And what's your number, sir?
Now, your name, your juror number?
284.
Okay, number 284 will not have to come back. So we'll break for lunch. All the other jurors will need to be back at 2:30. Please do not discuss the case at all with any, or engage with anyone else connected with the case. Ms. Hill.
All right, so that's going to take us down for this till lunch. So I'm just going to create a new thumbnail and create a new stream. And so they're down to 2:30, so I get an hour break. Yay. And then we'll be on for this afternoon. So you can, yeah, you guys can wait just a moment while I create a new stream for this afternoon. this is lunch. What was the last break for? To bring in a different jury panel. So they brought in some number of jurors, like 20 or something, and did a voir dire for the 20, and figured which ones were qualified out of that group. And now they're bringing in a new panel and doing the same thing. And I don't know how long they're going to keep doing that. They're going to keep doing that until they get some number of jurors, and then they'll have a new group and they'll voir dire from there, and so forth and so on. DM sent on Twitter. Let me take a look. I don't see any DM on Twitter. Not recently. I don't see any DM on Twitter. Sorry. Yeah, they seem to be rolling pretty good. Yeah. They have not selected any jurors yet. They have qualified jurors from the first panel. And then they're going to get qualified jurors from the second panel. And they're going to get some number of qualified jurors, and then they'll voir dire. So it seems like they're doing a filtering process. So it seems like they're doing some sort of initial voir dire to get a set of qualified jurors. If I understand what's going on procedurally, they're getting a set of initial jurors, and then once they have enough, they'll voir dire more thoroughly. So they have not selected any jurors yet, is my understanding. Okay. Copy image. Do this. Go over here. Paste this. Shit. Okay, logo. Put the logo in there. Right. So logo is about 250 by 250, I think, is what a standard do for logo. Okay, put that in the top right left corner. Great. Position backwards. Okay, great. All right, so I need to make this bigger. Make this bigger. All right, now let's see what I want to do in terms of. It looks nice. Okay. Now let's see, text. Okay, do text. Okay. Change font to this font because I like it. Change size to size 70 because we want people to be able to read it. Make it bold. Okay, change so that it's white on black text. Effect. Background. Okay, I want the background to be black. I want the text to be white. Yeah. Okay, now let's see. All right, spread. I want to reduce the spread. That looks good. Okay. Put it up here. Okay. Do this, Alex. Murder trial. Move that over here. Yes. Make it a little bit smaller. Move that back. See, where's my current thumbnail look like for this stream? Let's see. Where am I doing? Too many windows, too many places, too many things. Okay. Great. Let's see. Alex Murdaugh murder trial. Make that size 65. That looks good. Is that centered? Okay. Great. Copy this. Great. Okay. So what did I do? I just said Jan 23rd, right? Jan 23rd, a 1 p.m. I'm going to shrink his size of his image a little more. Let's see if I can shrink it a little more. Yeah, that looks nice. All right. Thumbnail. Great. That'll work for a thumbnail. Okay. Now let's see. I have to go into. Okay, I can do this. Go into Melon Streaming. Right. So I want to schedule. Oh, I can't. Okay. So can I do this? Can I create a new stream within this? Yes, I can. All right. So let me do this. I'm currently in a scheduled broadcast. I can't schedule a broadcast while I'm in a broadcast. Is that what we're learning? Lame. All right. Well, I'll just do it the hard way then. I'll just post a new stream and you guys will see it from there. So I'll post the stream and then I'm going to go have lunch. I will see you guys in about an hour. So make sure to check out the stream. I wish I could redirect you, but there's no way apparently for me to create a stream while I'm in a stream. Scheduled broadcast. I can do it. Yes. All right. So this is going to be at 1:30. That's my time. Yeah, 1:30 my time. Okay. And now what is the stream title? Okay, just copy the title. AM to PM. Right, where's my video description? Copy all that. Paste. Great. Upload thumbnail. Great. Fantastic. Okay, so schedule. Yes. And turn around, bright eyes. Turn around, bright eyes. Every now and then I fall apart. Need you more tonight. Need you more than ever. Great. All right. So this should automatically redirect you to the new stream so that you'll be able to see it. I've been Uncivil Law. I will see you in about an hour. Have a great one, guys.